Hey y'all, I'm Ada K. And I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Y'all, Discord is pissing me off today. We're going to have a conversation. This is like not good. So I apologize. Let's get back into trial. I apologize. I don't know what's going on with them.
Through their chain of command.
Now, the report that you have, I believe it's a 133-page report, correct? Something like that. Have you reviewed that?
No, sir, not all those documents.
All right. Did you review with anybody in your office the interview process or the process of eliminating a point of interest, Mr. Timberland Mathis? That name come to, you know who that is?
Yes, sir, I've heard his name.
All right. Did you review the interview process by which Mr. Mathis was eliminated as a person of interest?
I did not watch that interview, no, sir.
All right. Have you reviewed any reports by which Mr. Mathis was eliminated as a person of interest?
No, sir. I believe I met with our team. Again, we would do daily updates. And so if we did anything, it would be a meeting together.
Okay. Were you informed that Mr. Mathis was being deceptive during the course of his interview?
No, sir.
And what about any conversations or interviews with Jose Reyes or Jamie Towns, which is Jaylee's roommate? He's a person of interest just because he's a roommate, correct? Y'all interviewed him, right?
That name sounds familiar.
Okay. And Jamie Towns, another Khalid Fears. You're familiar with the interview with Khalid Fears, right?
I know we talked to Jose Reyes. I know Fears for sure.
Okay. And as far as Mr. Fears' statement, it appears that he has provided some information pertaining to his relationship or his connection to Mr. Lee that really wasn't 100% true early on in the investigation, right?
I'm not aware of that.
Okay. If there's a report that represented that he may not provided accurate information, you wouldn't have any idea about that.
I would love to see it. I don't have that report.
Now, if you would tell me, you indicated earlier that the investigation, the reporting process started between UPD and OPD, that was early on. Y'all were sharing information between each other. Fair statement?
Yes, sir.
Okay. And the report that you're talking about as far as the press release, do you know whether or not the UPD press release came out before y'all's?
The first one?
Yes.
Yes, sir. It would have had to because we shared it.
Were you familiar with the fact that Mr. Mathis provided information to the investigators that he knew that the report came out the day before the report actually came out? Did that come to your attention at all?
No, sir. Again, if you're referencing a report, I'd love to read it.
I got you. But it's not a report that you haven't read the entire file of the UPD file, correct?
No, sir.
Or the OPD file?
Not from start to finish.
When's the last time you reviewed the report of the OPD file?
I mean, as we do trial prep, I'm looking through notes, but I'm not going from
Not looking at the report.
the entirety.
Is it important to provide every time an officer does something as far as an investigation on a particular case, to whether or not they're interviewing a witness, they would keep up with that, place it in a report. Is that important?
If they're interviewing someone?
Yeah.
Yes, sir. We make reports.
And the information that you provided on direct examination pertaining to the searches, I believe those searches were conducted on November the 7th, 2024, the most recent searches, I believe at Lafayette Place here in Oxford, also in Grenada at Lincoln, on Lincoln Road, and somewhere, quote unquote, in a wooded area on Perry Road in Grenada County, November the 7th. Is that when those things occurred?
I don't believe Lafayette Place was November the 7th. I believe that may have been in September.
What date was it?
I believe in September of this year.
All right, September this year.
Yes, sir.
It was September this year, but the
Got enough ketchup?
most recent searches in Grenada County were on Lincoln Road and Perry Road, November the 7th.
Hey, guys, I'm sorry.
Right?
Yes, sir.
Can you explain?
Discord went down on me.
And myself, and even the DA, why that was not reduced to writing, placed in any report.
Sure. So Lincoln Road and the area around Perry Road had already been searched previously. We'd already been there. Nothing changed in November of 2024. It's very similar to us. We get calls all the time about a crime or an event that has happened. We show up and there's nothing there. And we call it HBO. It's handled by officer. We reported everything that we've done on Perry and Lincoln Road. There was nothing new, nothing of evidentiary value.
Sorry, guys, I'm frustrated.
Nothing to add to that report. That's why there's not a report.
Well, Chief, there's a lot of other reports in your file that indicate nothing of evidential value was found prior to these last two searches that have reports in. My question is not whether or not you didn't find anything of evidential value. Why did you not file a report that you didn't find anything of evidential value on those particular searches?
Because we had already previously searched those locations, nothing changed. There was nothing to add to that original search.
So that's why you didn't file a report?
On November the 24th
On November the 7th.
of 2024,
That's correct. In the September date.
yes, sir. We've already searched those locations.
Are there any other report? Did you authorize or direct them not to file a report, Chief, or they did that on their own?
No, sir. It's again, like I said, it's standard practice. We get a call about a careless driver on XYZ location. We go to that location. If we don't find anything, there is nothing to report. We go back 10-8 HBO.
Chief, you indicated that you wouldn't report anything since there was anything of value, but you would have reported something on the November 7th report if you had found something of value.
Yes,
Correct?
sir.
You agree
Hola.
with me, do you not? By you not finding anything of value, something that may be valuable to a defendant.
I'm not understanding your question.
Well, you think it may be valuable that if you've received information to go search a place, regardless you had already searched it before or not, may be valuable to a criminal defendant to know that you went back down there or went down there the first time.
And again, I think we reported that. That information was shared.
Of the November the 7th, 2024 search?
We spoke with the DA's office on that. We shared information.
but can you explain to me, according to the officer's testimony, I just testified the first time that we heard about it was 2 weeks ago yesterday, on a question that I asked an officer whether or not there'd been a Grenada and Lafayette place for searches. First time it was ever revealed was in a court of law. How can you explain that, Chief?
All I can tell you is we went there to search. We didn't find anything. There was nothing to report.
So let's talk about some other evidence in this case. If there's evidence that
Lay down.
an officer has gathered, retrieved it, evaluated it, and personally has determined that it's unreliable, should that be placed in a report?
That officer collected?
Collected evidence, let's say from search warrant. Collected evidence.
Why are
from
you
search
being
warrant.
asked about what another officer
Got
did?
it, looked at it, he talked to somebody or made a determination, even if the investigation revealed that it was unreliable. Should he put that in a report?
You're asking me a hypothetical?
I'm asking you as the chief of police for Oxford Police Department. If one of your officers gathers evidence,
And he logged that evidence. He logged it as evidence.
I've got a copy of it, that they got it.
But that's a
logged
report
that
then, right?
evidence. Should he report that he gathered that evidence?
You said you have a copy of it.
My point is, I'm asking you, should he report, if he makes the determination that that evidence is unreliable, should he put that in a report, just like a statement from somebody? You take a statement from somebody, put it in a report. If you think someone's being deceptive, right, or dishonest, right, you put that in a report. You evaluate that person's statement.
That sounds like someone's opinion. That doesn't sound like evidence. You're changing up on me. You're saying they gathered something, and now you're saying they perceived something. That's different. So perception may not go in a
Well, if you had
report.
an officer, one of your officers testify under oath that they gathered evidence, reviewed it, in their opinion, after talking to other people, it was unreliable. Shouldn't they put that in a report that they determined that they gathered it and they determined that it was unreliable?
And our officer put that in a report, is what you're saying.
No. If he didn't, would he have done something against your policy?
Dude, you're confusing.
He took it, he looked at it, he determined, in his opinion, that was unreliable. Should he report that he gathered it, that he evaluated it, and that he determined that was
Your Honor, I'm
unreliable?
confused. Help me out here.
It's really not. If we're out on a search and again, all of these
Bro.
locations, we ran across all kinds of things on the search. You may look at it, I may see a AA battery. Is that a part? I find it, evaluate it. Do I need to log that? Do I need to keep that? No. You move on. I'm not going to write every time I saw someone's cigarette on the ground or whatever we may have found in the woods. Yes, you have to evaluate what you see, but I'm not going to put everything that I came in contact if it was not pertinent to the investigation.
Chief,
I said, hang on.
The objection to the question is that it only, it goes to the credibility and weight of the evidence, provenance of the jury on each individual piece of evidence. And the chief has already answered the question as far as policy.
If you've got a more specific question you'd like to, if you got a more specific question you want to ask the witness, ask it. If you don't, move on.
Chief,
Whoa.
you execute
Whoa.
residents.
Back it up. Did you just see what happened? Anybody realize what just happened? You have a man who objected. Okay? this male district attorney objected, right?
Jimmie Herrington,
The defense attorney stood there quietly and listened. Watch the difference in the behavior between the male and female district attorney and how the defendant's attorney behaves.
It ultimately, it goes to the credibility and weight of the evidence.
Standing there quietly,
Each
waiting
individual
patiently.
piece of evidence. And the chief has already answered the question too, as far as policy.
If you've got a more specific question you'd like to, if you got a more specific question you want
Totally
to ask the witness,
different,
ask it. If you don't move,
totally different behavior on how the judge is responding, the lawyer is responding versus when the wonderful female attorney is up there. I'm not trying to make this about sex or race, but it is an observation. Saying.
move on.
Chief, you executed a search warrant on the residence of Jimmie Herrington on July the 22nd. His property, inside his apartment, and the resident key lock audit for his apartment.
Are you testifying?
Executed search warrants for all three of those. And if you got returns on all three of those, right? Shouldn't an officer provide a report about the return on those search warrants?
Yes.
Whatever we collect, we put in the return.
Okay. Now, once he
But if they don't,
evaluated that
they don't.
evidence, in his opinion, he decided the lock audit's not reliable. We messed up on the computer that was seized from Mr. Harrington's apartment. Or if we opened the door too early on his car before the execution of the search warrant. Those items should be listed in a report as to how he conducted his investigation, correct?
Objection.
Yeah.
Confusing question, compound question.
I think it's a reasonable question for cross-examination.
So you asked multiple questions. One,
I asked one question.
No, she asked multiple questions.
To answer the question.
You asked multiple questions. You said, should an officer put evidentiary, so if I get something, should I put it in there? You also said, should they talk about when they opened a car door or when they pulled? Those are all different things. They're not going to timestamp when I opened a car door. That there's other mechanisms of evidence that they use for that, for cameras or video.
Basic question, Chief. I laid out stuff. So
I like this cop. Oh, chief of police. He's good.
On July the 22nd, 2022, pertaining to evidence collected on that day, the same day that Mr. Herrington was arrested. That evidence was collected and logged, placed in evidence, and examined. If anything that was collected that day, whatever it was, piece of evidence was collected, and an officer drew an opinion at any point in time about the veracity of it or any of the problems with the evidence, shouldn't that be placed in a report? Yes or no?
I can't speak on his opinion. I can't make an opinion.
There you go, Doc.
assessment of should he write that in his report?
There you
That
go,
officer
Doc.
Has to say,
I'll move on, Your Honor. The lock audit that was provided as a return on the search warrant on July the 22nd. Are you familiar with the lock audit?
yes.
All right. Are you familiar with the fact that the lock audit search was executed and a return was provided to the Oxford Police Department?
I've not seen that. I know we asked for the lock audit.
If there was a search of the lock audit and a return done on the lock audit, should there have been a report by the officer that did that particular return on the lock audit?
Sounds like we did. We filed for it and we returned it. We filed for it. Yes, we filed for it and we returned it. That's the report.
After the officer that got it, that Detective Baker got it and assessed the lock audit, if he did any further investigation on that particular lock audit, resident lock audit, any further investigation on it at all, should it be placed in a report?
Based off the information he got on the lock audit, he should file what he knows on the lock audit.
Correct.
But the judge had
And
never
that's
seen
consistent
a lock
with
audit,
any other part of the investigation.
so he didn't know what to
of the
do with it.
Correct. You gathered information, got that information, if you provided evidence, you gathered evidence, if there's anything about that evidence that's remarkable, it should be placed in a report, right?
Anything that we are using as evidentiary value, we file.
Chief, I want to go over a little bit of the testimony that you stated on direct examination. Have you, to the extent that you know about conversations between Jay Lee and Jimmie Herrington prior to July the 8th of 2022, have you reviewed any of the text messages, Instagram?
No, sir.
You haven't reviewed any of that?
No, sir.
Have you reviewed the Snapchat conversations between Jay Lee and other individuals prior to July the 8th, 2022?
No, sir.
Have you reviewed any of Jay Lee's Snapchat, or any other platform, social platform of Jay Lee prior to July the 8th, 2022?
No, sir.
So what I'm assuming, your direct testimony about conversations that they had, things of that nature, or things that reported to you either through officers or stuff that you had read in the report as to what occurred that evening, correct?
On July 8th,
Conversations July 8th,
I've seen the July 8th conversations. You asked what I saw prior to July 8th.
July or prior to July the 8th.
I've not seen anything prior to July 8th that I've reviewed.
So you can't represent to this jury that there's anything in any report, any conversations between Jay Lee and Jimmie Herrington where Jimmie Herrington had coached Jay Lee over to his apartment before, threatened him in any way, or anything like that, Ken?
On July 8th,
July 8th, before July 8th, you haven't reviewed any of the text messages or conversations before July the 8th.
no, sir.
And on July the 8th, you represented that you had read all those text messages, Instagram. Is that in a report that was provided to you, but are you actually reviewed the return on the search warrant? Which one is it, Chief?
I've seen some of the Snapchat logs and then our reports.
And do you see anything in there that Jay Lee had threatened my client, that he was going to quote unquote out him at all?
At 4:36, Jay Lee states, I just wanted to say, which is outing, that I had you on the DL again, which is the download. Fun to have been your first guy experience. Jay Lee says, I wanted to say. He wanted to out him.
He wanted to out it? Is that what you say that means?
He says, I just wanted to say. Say is a verbal word.
But your indication is, your testimony here today is that that's an indication that Jay Lee was going to out Jimmie Herrington.
It says, I wanted to say it. He wanted to say that Tim was on the download.
Say it to other people?
Just says say it.
Okay. Do you have any indications from any reports from any officers, whether it be Detective Baker or anyone else, that there's anything in their investigation that revealed that there'd been any outing conversations between Jay Lee and Jimmie Herrington prior to July the 8th?
Nothing prior to July the 8th.
Do you have have you reviewed any of the other social media platforms from Mr. Lee's Snapchat account?
Snapchat's one account, one platform.
Excuse me, Jay Lee's other accounts other than Snapchat.
I've looked at a lot of messages, so I don't know what all, if they were Google's or I've just seen kind of a series.
Do you find anything in those Snapchat accounts that is consistent with the same type of conversations that you have in the July 8th Snapchat conversations between Jay Lee and Timmy Herrington? Late at night, things of that nature, and going over to other people's residence unannounced, things of that nature.
Did we find that in other, I'm not sure, I didn't go through his
You
account.
don't recall?
I didn't go through his account past July the 8th, or prior to July the 8th.
I want to hand you what's marked. Did you review all the way back to June the 14th pertaining to Jay Lee's Snapchat account with Mr. Fears? Have you looked at those?
No, sir, never seen that.
Never looked at it?
No, sir.
Before we go. That's all I have.
Number 23, you may read the rest. Y'all good? All right.
You were asked on cross-examination about
Wonder why everybody was trying to jump up.
the message from Jay Lee to Tim Herrington. I just wanted to say I had you again on the download. What did Jay Lee do after that comment was made?
He responds one more time and says, "I've nutted in your floor, so you should clean that up, by the way." And and the nude was fake. Okay, back to block now.
All right, back to block now. So was there any actions based on the records that Tim Herrington took that would indicate how Tim Herrington understood the message from Jay Lee? I wanted to say I had you on the download.
Can you reframe the question?
Based on that, what happened after that? Can you make any observations on how Tim Herrington understood what Jay Lee was saying as far as outing him to other people?
When Jay Lee makes that statement, then Tim gets a notification that he's been blocked on Instagram. Jay Lee then receives a Snapchat from this alternate account, Red Eye 24. There was kind of an immediate prompting at that point.
And who's trying to reinitiate contact in this?
Tim Herrington.
That's all I have now.
State calls the next witness.
Johnny, at this time, stay with us.
All right. Y'all approach 1 second. Gentlemen, Jerry, you've heard from the state that they've pressed on their case in chief, so you've heard the testimony that the state is offering. There's some things that the court has to do at this point. I'm gonna give you a long lunch today until 1:30. When we get back at 1:30, the state will finish that right when we call witnesses like this, and we're not call witnesses, whichever one it wants to do, okay? All right? Remember the course instructions, don't, talk about the case, don't allow anyone to talk about the case with you, don't form or express any opinions, don't investigate the case, steer clear of any media reports on this matter, and have a good lunch. Is this witness finally excused? Oh, that's right. Okay, you, chief, you can't get in the courtroom just that. Y'all have information, y'all get him back if you need him, right?
Yes.
All right, go back to work.
Thank you, sir.
All right.
I did what was directed to me.
The issues on the South authentication issues, or let the court handle them on his own.
Well, Your Honor, the court already ruled. I believe that ruling. I don't believe that that was the proper place or the proper subject of the directed verdict argument. The court has ruled there was sufficient indicia of reliability for those documents. It is not true that the only one tape would have come in. The campus walk videos, Your Honor, are from UPD testified to those. The campus walk, the campus videos, that's from the university. University police is in charge of the university. Those came in through the university. To the Renaissance Bank videos, the Renaissance Bank woman was here. The videos from the cleaner woman was here for that. Mr. Klink was here for the videos from his home. We called the witnesses. The other videos, Your Honor, was the Walmart video. The Walmart representative was here. So, Your Honor, that's not true that only one of these videos would have come in. The witnesses were here to authenticate them.
All right, I'll give you one beat, free buzzer.
Your Honor, first of all, cases she cited involving the embezzlement, there was clear evidence, as I understand the case she cited, Mr. Dagnall and I were discussing, there was evidence of the exact purpose of the representation about the purpose of the trip, getting that individual over there, which was false. There's nothing in this particular case, Your Honor. Mr. Pierce testified that the man was going over there to have some fun. There's no misrepresentation to Mr. Lee as to what the intent was when they were coming over there. There's one, according to their state's witnesses, Your Honor, there's one and only one witness testified, that chief, who wasn't involved in the
Rachel.
investigation, basically made reference to
I'm trying to get when I'm on the phone. I'll put it up here like that so y'all see I'm on the phone. Thank you. I just don't want to knock it over. Thanks. When I'm on the phone, I put it up here so y'all know that I'm on the phone. Hi, everybody. Welcome, welcome, welcome. It's been a day with StreamYard. Thanks for hanging in.
I just wanted to be able to say, I had you be the DL again, subject to multiple interpretations. How in the world are we going to move forward on an embezzlement case when the state has presented their proof that that is the evidence of embezzlement, Your Honor, during the course of the conversations between these two individuals? I can't imagine moving forward with that scant amount of evidence, going forward with the capital murder case.
Always double check. You're good, Rachel. Thank you.
Said that he couldn't present any evidence.
We are all good. Appreciate you.
That they'd had any conversations that supported that my client had lured him over there, that had any other arguments, anything like that, Your Honor. The second thing on the 902, The only tape that would have come in would have been the body cam.
You're awesome, Rachel.
The argument is that the procedure that was followed, Your Honor, was an improper procedure. That evidence, I know the court's ruled on it, should.
On those done at Grenada, I don't think the rule doesn't require.
Move your mic closer.
That there not be self-authentic, that you can't put them in, it just means you have to bring authentication, right?
No, Clint could testify, Your Honor, but what evidence at the time without the other videos show any crime? What evidence without the other videos and the Oxford videos showing a boxcar going down the road supports a conviction? If the court went back in chambers and said, you know what, I probably didn't do it right on that 902.
What?
No, you're not.
No.
But my point being, and I
Are you bullying the judge? Oh, yeah. He is bullying the judge. That to me is bullying the judge. And that angers me. Ugh. He's just trying to get it in there for the record, but that's not making me happy.
no disrespect to the court, but there's
Yeah,
nothing
there
in
is
that
disrespect to the
rule that
court.
talks about indicia of reliability. It's not in there, Your Honor.
Bleep, bleep, bleep,
All right,
bleep, bleep,
I'm ready.
bleep, bleep.
Unless
That's
you got
all,
anything
folks.
else? I don't mean to cut you
Can't
off.
think of anything else.
All right.
But
All right, I'm going to make, I'm this time.
now, hold on, Judge, one more thing about this order on this indictment.
Really, another one.
I hope we're not going down that path today on the capital murder case, that you can email an order, amend an indictment somewhere and stay here 9 days and not get it filed and signed by the court before the close of the state's case.
Oh,
Or even the
snap.
start of the case, to be honest with you. I hope we're not going down that path, Your Honor. Thank you.
Here we go.
Here we go. We're going down the path.
As to the self-authentication.
This is my disrespect.
Matters of videos, the court thinks it got it right. And I think we've made a record on this before, but I'll go back and sort of recap that. The state filed its notice of self-authentication. The defense filed a response in our court files. It was in a required time. You filed it within the required time. The state indicated that they did not get that notice, that the defense was objecting until it was brought to their attention on Monday, was 2 weeks ago when we was having court in Ripley. We talked about this in chambers. That was Monday before Thanksgiving. Court said we'll deal with it when we can have time. The court took it as we were having a hearing on it. As to those videos that the court was found were all here in Oxford, Mississippi, on a short route, all in close proximity in time, all in a route known to the court. Court found that those I was going to, if I had a formal hearing on the record, I would have allowed those documents to be self-authenticating. Time didn't permit it. From the time the state, a formal hearing, from the time the state found out that there had been an objection to the current time. If the court is wrong on that, I think there's still sufficient evidence and other means of this court that phone records, Snapchat records, records from Walmart, that there was self-authenticating, that there was authentication made, police department, university cameras and things like that, that the case could have survived a motion to direct verdict, even if the court was deemed wrong about that. as to the sufficiency of the evidence, I think the state has set forth a prima facie case that Mr. Herrington was alive, that he is no longer alive. There's a prima facie case that he came to his death at the hands of Mr. Herrington. Jury could see it that way. The good jury could see it another way. They made a prima facie case. They've also made a prima facie case that occurred in Lafayette County on July the 8th. And they've made a prima facie case based on the text messages, that I call them, communications between these two parties, that there could have been luring in this case. Don't know that that'll be for the jury to decide, but they've made a prima facie case. As to the issue of amendment of the indictment, the court on the record ordered that the indictment be amended, that court found that the statute required the code section of the underlying crime in a capital murder case be included in the indictment. Court further found that there's only one code section for kidnapping in the indictment, that there's no surprise to the defense. It can no way to change or affect the defense in this matter, with the fact that those few numbers for the kidnapping section, code section, be included in the indictment. Kidnapping is there's no different statutes for kidnapping. Court allowed the indictment to be amended to include the code section number for the kidnapping. I ordered that the indictment be amended. This court has no knowledge other than what's been reported to the court this morning, that it was emailed. We were in Hattiesburg, picking a jury for this case. State indicated when and where they emailed it to, and I'm going to deny your motion for directed verdict in this case. You can make any further record you like.
Your Honor, I think I need to clear up that the order failing
Boo
to
hoo
amend
hoo.
the indictment,
Aww.
the motion for directed verdict would be that the court should grant it. Alternatively, would be that due to the fact that the indictment wasn't amended, that it would move forward to the jury on, since the kidnapping aspect would not be viable, it would go to the jury on murder, as opposed to if the court found the prima facie showing had been made.
I'll ask for the state to make a response to that. They may be willing to confess that anyway. I don't know. The court is not going to, if the state wishes to move forward without the kidnapping, I'll allow them to.
What?
But if they don't, I'm going to play the cards we got, okay? That I'm going to. All right?
What? Hello? What? No. You didn't. Oh my gosh. Ugh. I wish I could get my new wheelchair in this office.
Let the parties both know what you've uncovered there anyway. Apparently the
Uh-oh. Something to do. This is not good. Ruh-roh. What is she showing? Oh, wish I could zoom in.
I'm not gonna make any comment on that on the record. If anybody else wants to, they can, okay?
At least from what I think provided, my understanding of consent is not anything close to an order amending the indictment and not
I will
signed.
say for the record, I have not signed an order amending the indictment. I have made a pronouncement from the bench that, so the record's clear, I
But
have
it's-
not signed an order amending the
Talk to you in a
indictment.
minute.
I have pronounced from the bench that the indictment would be amended for the record. That's where we stand anyway, okay?
I understand.
All right. It's 12:30. We got another hour, and we will, unless there's something else, will the state, you think the defense be ready to move forward? I would like to cover this right now in case I forget it later. Mr. Herrington, I'm going to direct this line of thoughts to you personally, not
Ooh.
necessarily to your attorneys. The state has rested its case. You have the right to put forth testimony in your defense. You have
Oh,
the
I got
right
it.
not to. You have the right to testify in your own defense, or you have the right not to. If you choose to testify, you'll be subject to cross-examination by the state. If you choose not to testify, the jury will be instructed that the fact that you did not testify could not be used as any evidence of that you were guilty of any crimes. The decision whether you wish to testify or not to testify is your decision. It's not the decision of your attorney. I encourage you to consult with them. They've been in this game a long time and know what they're doing. But ultimately, the decision to testify or not to testify will be your decision. I'm not going to ask you what that decision is at this time, but at some point before the trial is over, assuming you're putting forth other witnesses, which I understand you are, but even then, when you've called any other witnesses, I want you to be prepared to tell the court whether you wish to testify or not to testify, okay? All right? All right. Court's going to be in recess until 1:30. If y'all think of anything else we need to cover.
Wow. The state rests. Okay. Yep. That's strange. That's weird. What are y'all's thoughts? I really want to know. What are your thoughts? That's the whole thing. That's the whole point. The prosecution, I felt, did the best they could in presenting a case, but the defense has mucked it up so much that nobody knows whether they're coming and going, and maybe that's their strategic plan. Maybe that's their plan. Maybe that's where they're going with this. Maybe that's... Oh. Okay. I'm going to kind of go over for y'all what's happened. During day 6 of the J. Lee trial, the detective provided a comprehensive account of the steps taken by investigators before arresting Mr. Herrington, who was accused of murdering J. Lee. J. Lee was a 20-year-old University of Mississippi student who remembered and beloved of the Oxford LGBTQ plus community, went missing July 8th of 2022. In October, A judge declared Jay Lee legally dead, and the whereabouts of Lee's body is still unknown. Authorities arrested Herrington, age 24, 2 weeks after Lee's disappearance. Herrington is a 22-year-old Ole Miss graduate from Grenada when he was indicted on capital murder. Charging in connection with the case, Herrington allegedly unalived Lee to conceal the romantic relationship between the two. They were on the down low. Information of the timeline gathered in various surveillance cameras, countless witness statements, extractions from Herrington's devices, and subpoenas from data from different social media entities. The Oxford Police Department Detective Ryan Baker testified investigators never recovered Lee's phone. Below is the timeline of events before and after the Lee's disappearance. So we're going to run through this real quick. At this point, everybody's already said it, and I'm after 2 hours. Appreciate it, though. I mean, I don't know why they can say it in court, we can't, but okay, thanks for reminding me. All right, at July 8th at 2:54 a.m., Lee sent a text message to Herrington, said, "You in Oxford?" At 4:01 a.m., Lee's phone pinged at his residence at Campus Walk Apartments. Surveillance cameras captured Lee at the apartment complex. At 4:05 to 4:14 a.m., Lee's phone pinged in the area of the residence at Lafayette Police Department. Baker testified detectives learned through Herrington that Lee was at Lafayette Place. This information was confirmed by Snapchat message between Lee and Herrington. Oh, that's right. Oh my gosh, you're right. We've been streaming multiple streams. That's what happens when you have to start and stop. Okay, thank you. After 4:36 a.m., Lee arrived back in his apartment and messaged Herrington on Instagram and said, "I just want to be able to say I had you." Be the DL again. Down low. Fun to have been the first guy. Experiment over. Ooh. 4:53 a.m. Lee told Herrington, "Also, I explicit on your floor, so you should get that up, by the way. Oh, and the nude was fake too. Back to block now." So Lee had blocked him again. According to Baker, those messages showed Herrington was on the down low or not openly gay, but that Lee and Herrington's first same intimate relationship. Baker testified that Herrington's grandfather was the bishop of a church in Grenada and several family members served on the church's staff. Baker said the family was well known in an affluent community. Baker testified that Herrington was not openly gay and did not present himself as that kind of man when communicating with friends and family. Wow. Welcome, Eddie. Thank you guys for hopping on. So then, at 5:15 a.m., Herrington received an Instagram notification that Lee could not receive his messages, meaning that Lee had blocked Herrington. 5:17 on Snapchat, Lee asked Herrington, "Who TF is this?" Herrington was using a Snapchat account identified as Redeye-24, not his own. Herrington called Lee 3 times, twice at 5:19 a.m. and one at 5:20 a.m. All calls were unanswered by Lee. 5:23 a.m., Herrington called Lee through Snapchat using the Redeye-24 account. The call lasted about 14 seconds. At 4:24 a.m., Lee asked Herrington what was deleted. At 5:25 a.m., Lee told Herrington, you made it like this." Herrington responded, "Come back." Y'all, this is some drama. At 5:26, Harrington asked, "You coming or nah?" At 5:27, Lee responded, "No." Harrington said, "Why not?" 5:34 a.m., Lee said, "You wouldn't even eat my blank 1 hour ago after I cleaned and everything. Then you proceeded to blank in my mouth. Hopefully you ain't been blank with nobody raw." Then asked if I'm going to stop harassing you, that you want to stop linking. You know how much of a blank move that is, you fool. Whoa. Wowza. Oh, wowza. We didn't hear all that in court, did we? 5:35 a.m. See, court is really hard to hear. Lee said, like, you did some questionable blank, but that's right there was too much. Have a good night, Tim. 5:37 a.m. It's like, good night, my butt. It's already morning. 5:37 a.m. Lee said, "Yeah, now it seems like you're just trying to lure me over there to beat my blank or something." Stuff is blowing up, y'all. Harrington, you're tripping. I do feel bad because we cool. I ain't trying to end things like this. Message continues from 5:39 to 9:48, and Lee said, "You know, if trying something fast, it won't end good for you." Harrington said, "WYM something fast?" Lee said, "Like try and hurt me or some." Harrington said, "I know." At 5:51 a.m., Lee said, "Possibly later tonight." Harrington responded, "LOL, I just told you I'm leaving later today." Lee responded, "LOL, okay, we fixin' to see if you're lying." Harrington said, "Lying about what?" 5:44 a.m., Lee said, "Make it up." And then he stated, "I'm coming." At this time, according to Baker, Lee had agreed to come back to Harrington's apartment, testimony in which was backed up by Harrington's admission. Wow. Yep. At 5:57 a.m., Harrington searched on Google, "How long does it take to strangle someone, Gabby Petito?" Harrington also Googled, "Does pre-workout boost testosterone?" Does workout boost testosterone? That's interesting. This information was pulled from Harrington's cell phone, MacBook, and Google's search warrant. Does it? Does anybody know? Do you know, Dr. B? Baker testified, when someone starts searching, how long does it take to strangle? This was the first Google recommended result. Baker also said the search was significant because Harrington had been up for a long time and that pre-workout provides energy. 6:03 a.m., Jay sent a Snapchat message to Harrington saying, "Open." Harrington admitted to the police interrogation that Lee had returned to his apartment. Lee had never sent another Snapchat message. At 6:08 a.m., Lee's phone pinged the area Lafayette Place apartments. At 6:12, Lee's phone pinged the area of Harrington's apartment. Harrington confirmed in his new interview that Lee had come back over to his apartment. The two apartments were only 0.3 miles from each other and would not take long to get to each other's apartments. At 6:38 a.m., Harrington searched on an Apple Maps for a trip from his residence to Walmart. Harrington confirmed the investigators that he did go to Walmart. At 6:49 a.m., Harrington bought duct tape. How long does it take to strangle somebody? So if you take something that enhances your energy and strength, will it affect the time it takes for you to unalive? At 6:51 a.m., Harrington left Walmart with his white Ford Escape, heading west on Jackson Avenue to the Link Apartments, where his moving company box truck was parked. At 6:57 a.m., Harrington came back into town, headed east, passing Kokomo's Chevron gas station towards Lafayette Place, but this time he was driving the box truck. Yeah, no, right, Eddie? At 7:02 a.m., Harrington made it back to Lafayette Place Apartments. This information was confirmed by Harrington's cell phone location data and Harrington himself, who told investigators he went back to his apartment after leaving Walmart. Not too sure about that. At 7:18 a.m., Lee's car passed the Rainbow Cleaners on Jackson Avenue. At 7:21, Lee's car traveled to an intersection of Rebel Drive and Jackson Avenue. At 7:23, Lee's car traveled north on Molly Bar Road by Rocketville. So Lee's car was traveling around. At 7:25, Lee's car hit Molly Bar Trails Apartments, shown by the surveillance camera. Baker said Lee's car was found with tires over the line and its wheel turned to the left. To him, this implied the person who was parking the car was in a hurry. At 7:28, Lee's phone pinged near Stone Park Residential College South. 7:34 a.m., Baker testified Harrington can be seen running out of Molly Bar Trails with a shirt around his neck and a gray hoodie. All right, this is getting pretty convincing to me. I mean, if I'm on a jury and all of this crap gone through for 7 days, I would rather have this. Just give me this. I'm floored. I've learned more from this than I did from the trial itself, from all the shenanigans. Around 7:40 a.m., the driver of a Kia Optima was traveling on Molly Bar Trails when he saw Harrington jogging with a gray sweatshirt. The driver testified that Harrington told him he needed a ride back to the apartment. On the stand, Carter describes Harrington's condition: sweaty, but not heavy sweat. He'd not jogged for too long. What? Did you get to see some people, Sensei? Baker showed a diagram to the court of the temperature around the time. It was 86 degrees with 70% humidity. Anybody's going to be sweating in that. Witness testified interacting with accused unalived person on the day that Jay disappeared. So what do y'all think about this? Sensei, stop. I can keep going. This is a forever timeline. This has been an hour just to go through the timeline. But it's a fabulous timeline. I don't think he'll testify either. He's stupid if he does. I believe he would be stupid if he testified. Well, the crime aisle has a lot of good stuff on it. I was looking at stuff for camping, just kind of getting a list of things that I needed, and just kind of figuring out what I needed and budget and everything for in the spring. And oh my gosh, now when I go down certain aisles at Walmart, I'm thinking, Yep, we heard about that in an unaliving. Oh, someone used that to unalive somebody. Now I'm going to look at duct tape and think of Jay. House long seems to come up in a lot of trials. So we have until 1:30. It could. I got a pick, crowbar, a hammer, stakes that you tie the tent down with, but mine are the kind that you can screw in with a Dremel, so it's really good. A lead shooter or two, some lead. You never know when you get a slithering critter. Yeah, I can go down the list. You're right. That is so good. Oh. What, baby? Oh, did he not give you your cheese? I need me something to help quit yawning. I didn't go to sleep till after 4 this morning. After 4. Maybe I ought to create a duct tape emoji. What do you think? I think I will. Memorizing lists instead of writing them down. Tracy taught me how to do lists in Amazon because I wasn't a big Amazon shopper before. I mean, I'd shopped off of Amazon, but I didn't know about you could make all these lists and everything. Girl, I got my dream camping list. Now, if I bought everything on that thing, $5,000. I'd show it to you, but I'd get in trouble. Good morning, Carmen. Carmen, you're missing it. This is crazy. This trial. Oh my gosh. The way the judge is behaving with the defense. Oh my gosh. And by the way, those who've been watching, did you notice, or is it just me, the behavioral and body language changes when the male on the state side stood up to object versus the female? I'm not trying to be mean. I'm not trying to be, pro-woman and everything, but every time the female prosecutor would object, the defense attorney would literally talk over her, argue all over her, and never get a word in. But when the male prosecutor objected, he shut up, let him speak. The judge decided, and that was the end of it. I'm just saying, go back and look. Go back and look. Looky-loos. What, baby? Sensei, lay down. Down. She's sitting here with her head in my lap like she's begging. She's been fed, she's been watered, she's been TT'd, she's been poo-pooed. She doesn't need anything else. Y'all. How do you like my little reindeer? Grandma got ran over by a reindeer. I know. I get you. Sorry. Sensei, settle. Down. 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 Kennel. Well, that got her down real quick. We love Sensei. She's great, but she's being super clingy since my sis passed away. And I know why, and I appreciate it. But at the same time, it's like, oh. So anyway. I can't quit yawning. I'm looking for videos on something else. So, Lugini, or whatever his name is, Magione, is set to arrive in Pennsylvania. The court date was set for December, court set for December the 10th. What? That's today, isn't it? That is so true, Ronnie. I'm glad you said it. I'm going to share this. Let's see if I can get it to play. I don't know how long this is, but let's watch.
Bring him.
One thing that bothers me is I understand they're making such a huge big out of this guy's unaliving. And trust me, anybody who gets unalived should be a big deal. I get it. But because he was a CEO of a healthcare company and this happened in public, what about all the other people who are unalived in more horrendous ways than this guy? They don't ever get the amount of resources and police and all of that on their cases. Only because this went national is the only reason why they've got all this. It just unnerves me. Everybody should get the equal amount of effort. Honestly. God, I'd hate to park in that parking lot. Especially with all the people there. It's harder to turn. Yes, they've had practice. Making me dizzy. I gotta do that. This guy's making me dizzy. Yeah. I know it was New York and it was daylight, but do you know what? There's a lot of people who could have 1/10 of the financial resources put on their cases of their unalived family members. A lot of cases would be solved. Yep, exactly. And that bothers me. I think that's horrible. There are shootings downtown San Antonio, middle of daylight. Since I can't put my feet down. Move.
Saw you on the news. He lives in Kentucky.
She gets right where my feet are. Sensei, come here. Sensei, here. Here. Now lay down. Lay down. Good girl. So, I know. I mean, there's shootings all the time. Daylight. Trying to just zoom in. This is true. I'm just saying. There are a lot of cases like this that happen that we don't hear of because the person's not a CEO. Oh, snap. Let's see it. They're going to be quick and swift. He's not going to be cooperative.
It's completely out of touch and it's an insult to the intelligence of the American people and its lived experience.
Whoa. Oh, dang, Dr. Bullbutter. My apologies and sympathies. That was handled well. How interesting. Okay. We got that. That was interesting. Wow. Ah, I need to go back and get that then.
The shooting death of United Healthcare CEO Brian Thompson in New York City. Luigi Mangione was arrested at an Altoona, Pennsylvania McDonald's on December 9th after an employee reportedly tipped off police that someone resembling the suspect was in the restaurant. An Altoona police officer approached
I understand.
Mangione.
He had asked the suspect if he had been in New York City recently, and that really invoked a physical reaction from the suspect. He became visibly nervous, kind of shaking at that question.
Police say Mangione gave officers a fake ID, and inside his backpack was a written document expressing his hatred toward the health insurance industry.
In some dark corners, this killer is being hailed as a hero. Hear me on this. He is no.
Can you? I can't believe they're having contests for the most look-alike. People are getting his tattoos with the hood and the mask and only his eyes showing. People are showed up and copied what he was wearing the day after and had a little, what they tried to have was a rally, but I don't think that's what you can call it. But I was like, are you kidding me? I didn't put it up on YouTube because I'm not going to promote it. I think that anybody who wants to dress and look like this guy to get attention, you're sick.
No hero.
You don't
the
like
real
it.
hero in this story is the person who called 911 at McDonald's this morning.
Yep.
Online court records show Mangione was charged in Manhattan with second-degree murder, along with 3 gun charges and forgery. He is expected to be extradited to New York. This is Inside Edition Digital.
Wow. That's insane. Okay, everybody's going live with this. Everybody is going live with the video. I get it. I get it. We'll watch it again. Let me get it on stage. Okay. Oops, didn't mean to remove it. We'll move it all the way up. Let's play it back. 50. Let's see if we can get what he said. And here we go.
And clearly out of touch, and it's insult the intelligence of the American people and lived experience.
Trying to figure it out. Yeah, we will go over that eventually.
And clearly out of touch, and insult the intelligence of the American people and lived experience.
Unjust to American, it's an unjust to American people is what I got. Wow. Oh, this is insane. It so freaking grieves me right now. It so freaking grieves me. Family reported a United Healthcare CEO suspect missing in November. Okay. Oh, let's hear this.
Suspect's background and his family's deep influence across the state following this intense 5-day
No,
manhunt.
he's hyped
Shannon
up.
Lilly is joining us live with where the case stands now and how the Mangione family is responding. Shannon.
Even the fact that media is covering.
Okay, she's next to a generator. Let's read it. Oh, get away from the blower. Thank you.
Reacting, not happy that media is out here covering the story in general. Others have been murmuring. They're saddened by this news. This is students are making their way into the Gilman School here behind me. School starts right at 8 this morning. This says 26-year-old Luigi Mangione is now officially charged with second-degree murder in this high-profile killing. Remember, he was a student
I'll have you on a
at
live.
this school, and now he's charged with murder in the brazen killing of United Healthcare CEO Brian Thompson, a crime at the center of a days-long manhunt as the world watched on, now with ties to our region. In fact, he is the cousin of Republican State Delegate Nino Mangione from Baltimore County.
I feel bad for him.
And take a look. Delegate Mangione now putting out this statement on the arrest, saying the Mangione family cannot comment on the news reports about Luigi, and they only know what they have read in the media. The statement goes on to say, quote, "Our family is shocked and devastated by Luigi's arrest. We offer prayers to the family of Brian Thompson, and we ask people to pray for all involved." Meanwhile, during a news conference Monday evening, Pennsylvania Governor Josh Shapiro condemned the violence, and police in New York City noting more than just weapons were found on Mangione when he was arrested.
Additionally, officers recovered a handwritten document that speaks to both his.
This
Can we
is your
saw that?
first look at the man police say is responsible for the shooting death of United Healthcare CEO Brian
Not what I
Thompson
wanted.
in New York City. Luigi Mangione was arrested at an Altoona, Pennsylvania.
We've already seen that. Wow. What do y'all think? That is crazy. I'm trying to get more videos. I'm looking. I was hoping they'd have court. Yeah, I would say so. It's an insult to the intelligence of the American people. Malibu wildfires and Franklin fires. Oh, we got a lot of fires I didn't know about. I'm looking. I am also. Sorry, I'm just looking. Y'all, if you live in the Malibu area and all that, please be safe. Well, I think he knew he was going to get caught, honestly. I mean, let's think about it. I think he would have figured out that he was going to get caught, and this was going to probably ruin the rest of his life. But it I don't know. I'm not going to argue it. That's what I want to know. That is exactly what I want to know. Okay, this was released 2.5 hours ago, 2 hours ago. Let's watch this. And thank you very much, WBAL-TV News.
New York City.
We had been following the developing news all day that Mangione had been identified as a strong person of interest, and he's now a suspect. We also found out that Luigi Mangione is from Towson, whose family ties run deep in the Baltimore area.
The 26-year-old who was walking into a courthouse tonight was the valedictorian of the 2016 class at the Gilman School in Baltimore.
We have team coverage tonight. 11 News reporter Kyrie Stewart spent the day chatting with former classmates at the Gilman School.
11 News
God
anchor
help 'em.
Ashley Hinson is looking at the perplexing online response to this crime.
But first, we want to go to 11 News anchor Jason Newton at the live desk. So Jason Mangione was arrested today in Pennsylvania.
Right, arrested and facing lesser charges initially as a person of interest in Brian Thompson's murder. Now, as you said at the top, Mangione facing murder charges in his death. First, though, let's start with a statement released by the suspect's family tonight. The statement, it reads, "Unfortunately, we cannot comment on news reports regarding Luigi Mangione. We only know what we have read in the media. Our family is shocked and devastated by Luigi's arrest. We
The
offer our
family is
prayers
not
to the family." Now, this
responsible
was
for
posted
his
by State
behavior. He's
Delegate
a
and
grown
cousin
man.
Nino Mangione. To the charges now.
I kind of got mad because I was watching a live last night and everybody was going off about the mom and the parents and the family. And I'm like, dude, this guy is a grown man. He makes his own decisions. I'm sure they did not tell him to go out there and do this. And if they did, well, they deserve to be in jail. But he's a grown man. He can make up his own mind, his own decisions. And now they, too, are harmed and victimized in a different way by his behavior.
Manhattan prosecutors have filed murder and other charges against Mangione. Back in Pennsylvania, though, where he was captured, he remains jailed, facing charges based on his interactions once Altoona police were called to a local McDonald's. Those charges, one felony count of forgery and one felony count of carrying a firearm without a license, among others. Mangione was arrested without incident this morning. A McDonald's employee spotted him just sitting in that Altoona fast food restaurant. Police were called. According to charging documents, they found a 3D printed gun and silencer. When asked for ID, police say he gave them a fake New Jersey license with a different name and a different birth date. According to court records, Mangione also had writings against corporate America and the health industry.
My partner and I recognized him immediately, just from what we saw in the media with photos, videos. We just didn't even think twice about it. We knew that was our guy.
Within several minutes, seconds of the first contact, he had asked the suspect if he had been in New York City recently. And that really invoked a physical reaction from the suspect. He became visibly nervous, kind of shaking at that question.
Now, if you are from the area, the name Mangione is well recognized within this region. Nino Mangione, as we mentioned at the top, a state delegate and cousin. His grandfather, a developer and philanthropist. Their family's name adorning the Loyola University Aquatic Center, and they're owners of Turf Valley and Hayfields Country Club. Their giving, all guided through the Mangione Family Foundation.
That classmate told me that he was in the same graduating class as Luigi Mangione, and gave me some insight to who he was as a person during their time as classmates.
The class of 2016 has been coming up with new ideas and challenging the world around it.
This is video of Luigi Mangione back in 2016 at the Gilman School.
I showed you this
Person of
yesterday.
interest in the death of United Healthcare CEO.
Many of the students characterized our class as inventive in both imagination and initiative.
It's just so shocking and does not really track with what I thought he was as a person.
Freddie Leatherberry says that he was in the same graduating class with Mangione in 2016 and is still trying to wrap his mind around the situation.
I can tell you that this is one of the last people you'd think would do something like this. You know, he was one of the nicest kids, most friendly kids that I had known at Gilman.
Leatherberry says that Mangione was at the top of his class academically and was well known around school.
There was nothing came off weird about him. He had great friends. He had a lot of female friends as well. He was a relatively unassuming kid. He was down to earth. He was smart, well-adjusted socially. He was at least a two-sport athlete from what I can remember, and he really had everything going for him.
The Gilman School released a statement reading in part, quote, "This is deeply distressing news on top of an already awful situation. Our hearts go out to everyone affected." Leatherberry says it's an unfortunate situation for everyone, especially the families involved.
I hope that they can heal as a family, and certainly the family, of course, of Brian Thompson, of course, is in everybody's forefront thoughts and prayers as well.
I got it, Zach.
That's just terrible for them, too.
Leatherberry says that he hasn't had any contact with Mangione since their time as classmates, but told me, like many others here, that this whole situation is sending shockwaves throughout the community.
And it
In
doesn't look
Baltimore,
good for their
Kyrie
school.
Stewart, WBAL TV 11 News.
I
Police
mean,
have a quote strong person of interest in custody for the murder of the United Health.
we already know
at
that.
New York were found believed to be similar to the one.
To remove him off.
It's one of the two country clubs that we've learned that the family owns. The other is Turf at Gilman School, which is often ranked as one of the top affluent.
Okay, we've already seen all that. Y'all, okay, Zach, I'm still older than you. I own it. I think I'm older than you, aren't I? I don't remember. I'm too tired. I am so trying not to fall asleep. By the way, I just downloaded a picture of him, but I'll just go ahead and share screen. This was him sitting there eating. Somebody snapped a shot, I guess, before the cops got there. Ronnie, are you older than me? Well, I know Adair. You're older than us, aren't you? Yeah. That sheriff is another trial we're going to have to follow. Excuse me. Let me get this off of screen. I didn't even mean to put it on screen. Oh. Y'all, I'm so struggling to stay awake right now. Mm. Yep. I'm looking. I'm looking. Oh, I gotta say hello. Hold on. I'm looking for something. I'm sorry. Looking to see. Trying to find anybody can help me find a video of court, if there is one? We got a different angle. I'm gonna play it soon as the commercials are over. Yeah. So, one thing that I wanna say that you got people on 2 sides of the street. One side of the street, he's crazy. The other side of the street, he's an activist. Well, there's not a single person out there that knew him thought he would ever do this. No one ever thought he would be doing this. Let me share this. Let me come back. We're gonna. Let me get this set right.
Pennsylvania, take a look.
And it's completely out of touch. And it's an insult to the intelligence of the American people and its lived experience.
Our folks who were there say, I mean, obviously it was difficult to hear, but he said something along the lines of that's an insult to the American people and their lived experience. That extradition hearing obviously is about getting him back to New York, the scene of the crime. We'll have much.
Yeah, Chris, good to be with you. Obviously, a very electric moment as Luigi Mangione appeared at the Blair County Courthouse, appearing right to
That's a
talk
good
to
word
those
to
cameras,
use,
saying
electric.
something along the lines of completely out of touch, and it is an insult to the intelligence of the American people. It's not entirely clear what he said as he is slammed against the wall there as he's making his way into the courthouse, but he was clearly agitated and clearly had something to say. That is the most animated we have seen him. This is the same courthouse where he had his appearance yesterday before a judge, where he was listed and read the charges that he faces here in Pennsylvania, the 5 charges, those 2 felonies and 3 misdemeanors, to which at that point he was very quiet. He only answered yes, no, yes, sir, no, sir. It was only after he was denied bail that he did speak up, Chris, and that was one of the first moments where we actually saw a little bit of his demeanor and a little bit of that attitude change when he questioned when prosecutors said that he had about $8,000 in a bag they found with him at the McDonald's, as well as a bag that was described as high in tech, to which Mangione said, I don't know what you're talking about. I don't know where that cash came from. And as far as the high level of sophistication you're referring to, well, that bag is simply just waterproof. But beyond that, we've usually just, from up to this point, again, very solemn, very quiet up until this outburst. So again, that moment now playing out. There are no cameras, no electronics allowed in that courtroom. So our team inside is presumably gathering all of that intel of what is happening inside of that extradition hearing, which again was supposed to take place about 1:30. So at any moment, we will learn the fate of whether or not he is heading to Manhattan to face those murder charges for the murder of CEO Brian Thompson. And again, of course, this entire community rattled by all of this that unfolded here yesterday. The deputy chief telling me earlier today, this community is getting threats now, Chris, as far even the police officers here, the department itself. So they are hoping this.
Wow, they're getting threats? Are you kidding me? Now we're going to start having riots and everything else. Aww. Y'all. I didn't think they'd have court that time of the day. Oh, my back. Sorry, I'm trying to move without crying. My back is just so not happy. Y'all, this is insane. We also have more stuff I need to talk about for the sheriff situation, but I'm trying to find. But all of the videos are now popping up, or this guy. I'm pulling it up. Hold on. Oh, yeah. Oh, yeah. Even if it's a 10 million, they'll come up with it. They always do. They always do. Especially when you've got a bunch of vigilantes and people like, and I hate using that word, but you know, people going out there getting tattoos of this guy in his hoodie and everything from the day of the shooting. I was just absolutely floored and angered when I saw that. When was this? Okay, there we go. Get it up.
So far about this guy, about Luigi Mangione, and if there is any potential motive that's been identified by
I'm going to let this
investigators.
run. I'm going to go to the
Good
ladies'
morning
room.
to
I'll
you
be right
too.
back.
We are all trying to figure out right now why. What was the motive behind this fatal shooting of the CEO of United Healthcare, Brian Thompson? What we do know right now is that there are two possible indicators for potential motive. One from police and the other from the internet. From police who approached and found Mangione in that McDonald's in Pennsylvania. We know that that was on his person was found was a document, a 3-page handwritten document that police say could lead to and clarify a motive and the mindset of the suspect in this shooting. And in that document, which has not been released yet by police, a senior law enforcement official has said that the document actually listed and named United Healthcare. In the document also, it included how much the company makes and the size of the company. We also know that it condemned the health industry for prioritizing profits over people. The other possible indicator for a potential motive we know is that Mangione had a Goodreads account. That is a book catalog website, a social media account, as you would say. And on this account, he read books about chronic back pain or listed that he wanted to read these books. It's not clear if he had yet confirmed if he had chronic back pain, but we know that he was reading and looking for these books. And he also reviewed a manifesto by the Unabomber. You will recall that the Unabomber is a domestic terrorist who sent bombs through the mail. And so we know that he reviewed this manifesto and even wrote in the manifesto that violence is never the solution, is only a statement uttered by cowards. So we know for sure that right now we're looking at everything on social media, but also listening to police as they start to come out with more information as to Mangione's, the suspect's motive.
Okay, Dia, what are we hearing from the Mangione family in response to Luigi's arrest?
Well, we've already actually had a statement listed from the family on X by Nino Mangione, who is a Republican member of the Maryland House of Delegates. And Mangione said the family, in the statement, he said the family is shocked and devastated by Luigi's arrest. They also offered their thoughts and prayers to the family of Brian Thompson, the CEO of United Healthcare. And they also said that they are devastated by this news. And so we're slowly hearing from the family. What we do know about this family is that they are a wealthy family in and from Maryland, where Luigi Mangione is from, and we're slowly gathering more information about Mangione.
Okay, Dia, I want to ask you about where you are. So outside near the Hilton Hotel where this incident took place. Curious if it's business as usual, if you see anything out of the ordinary this morning. Kind of describe it for us, if you would, please.
Absolutely. We're here in Midtown in Manhattan, right outside the Hilton Hotel where the shooting had taken place. This is honestly, it appears as business as usual for many folks. But I can tell you that I've seen at least 3 police cars circle the block that we are standing on, driving past slowly, just checking. Many of the passerbyers look like they're just headed to work or headed to pick up coffee or breakfast. There isn't a lot of police tape, a lot of police cars blocking the streets. Right now, it appears that a lot of folks are still cautious of what happened here last week as they're walking around, taking photos and videos. And as I said, police cars are still circulating this area. However, it appears that it is business as usual, especially here in New York.
I appreciate your reporting, Dia Tubman, Scripps News correspondent. Thank you so much for joining us this morning. We'll speak again soon. Let's continue the conversation now. I want to bring in our guests we have in the studio, our legal analyst guest, attorney Erica Wilson, and joining us remotely, our law enforcement analyst, Claudia King. So let's dig in more about this guy. Did he want to be caught? Erica, I want to start there with you because we were having a little bit of a conversation off camera about some of these indicators that makes you wonder, was he surprised when he was taken into custody on Monday? What do you think?
I don't think so. I think everything that this guy has done has been very strategic and very methodical. So we think that, he got caught just going to the McDonald's. I don't think it's that easy. He's been leaving little Easter egg clues all around, including the messaging on the bullets, including the Monopoly money in his backpack, including his YouTube channel that said, hey, if you see this, I'm in jail. right?
Right.
And so you can't put that much effort. And I believe that YouTube channel was started back in January of this year. You cannot put this much effort into planning. And let's understand, he's a very smart guy. He went to one of the best private schools. He went to an Ivy League college. So, you know, he has the intellect to be able to put all of these things together. So I don't believe it was just happenstance that he got caught at a random McDonald's somewhere. I think all of this was pre-planned. Like we'll find out what the message that he's really trying to send with all of these little Easter eggs eventually when if and when he ever speaks, which I think that he will. It's been too sensationalized. He's too much of like, you know, a modern day hero, if you will, with that Robin-esque kind of vigilante justice for the people type of situation.
Yes.
So I do anticipate at some point we will probably hear something from him or get some sort of indication as to what these little clues were about, including but not limited to how you just accidentally on purpose got caught at a McDonald's.
Right, right. I like how you called them Easter eggs, these little hints being left behind, little clues. He left a lot of evidence for investigators to go after to identify him and then arrest him. And then that 3-page document that Kadia was just telling us about that he has on him in the McDonald's referencing United Healthcare. Claudia, tapping into your law enforcement expertise, I'm so curious. One of the biggest questions I have, and maybe some of our courties at home are with me, tweet me if you are, I'm wondering if for the sake of our analysis, just because he's innocent until proven guilty, so he's just charged at this point. But let's say for the sake of our analysis that he's the guy, he did this. Were there more kills to be done, or was his axe to grind just against United Healthcare? I think that's my question about all this. I'm curious what you think. If you think this guy was perhaps a greater danger than to just Brian Thompson, the victim shot and killed in New York.
The one reason that I don't think he was a greater danger is because he was so out in the open afterwards. So he was at the McDonald's. I feel like if there were more kills that he had planned in that moment, that he would have stayed kind of underground for longer so that he could accomplish those tasks as well. So I think perhaps this was a one and done. I think maybe we'll see that he or a family member had United Healthcare, maybe had some issues with coverage, maybe related to the back pain, and this is what drove him to do this. So it's very interesting, but I agree with Erica. He wanted to get caught. He has that manifesto on him. We've only heard bits and pieces of it. So I think there's a lot more to come. And I agree that we will hear from him on why he targeted this one individual in particular.
Yes, exactly. Great points, Claudia. Erica, tell me, when we think about the potential motive, we know it could be potentially chronic back pain. There are reports that that's what he suffered from. How do you envision this case playing out? So it's been so public. His pictures everywhere. Like you said, you theorize that he potentially wanted to be caught. I mean, do you think this is even going to be a trial? I'm curious what you think legally, tapping into that expertise that you have.
I'm still trying to figure out his motive and like all of this that he's doing and for what purpose. And so I think because it's so sensationalized,
And the 3 unused leads had words written on the casing. So those were not meant, I don't know. There's a lot of weird stuff here I don't understand, Zach.
believe that there will be a trial. He has a bigger message. I don't think it'll end here. I think it has to go to trial so he can get out that which he wanted to convey. Because again, with those little Easter eggs, and your producers put up the picture of him holding a Happy Meal, I think everything is very thought out and very strategic. And so it's going to go to trial. There will be no pleas. There will be no, anything of that nature. We're going to go to trial. He's going to have his day in court. And when the trial happens, it's going to be, the word circus doesn't even do it justice. It's going to be something that everybody is going to want to see, because we all want to know why, the whys. Because again, you come from an affluent family. We can't presuppose that you had issues.
I suspect he's going to become the male version of Sarah Boone. to some degree or another.
With insurance. I mean, I would guess if your parents own a literal country club, that even if insurance didn't pay, your health care would be covered. So we don't know. This is the ignominy we had in our minds. This is somebody disgruntled because the insurance didn't pay. I don't think that that's it. This is bigger than that.
That's a really interesting point, Erica, because it seems like he may have perhaps kind of, to use the cliche, grown up with a silver spoon in his mouth. Like the grandpa bought 2 country clubs, right? So, he's going to private school. He's valedictorian, Ivy League, another private school, for college. Yeah, that's a really great point. Was he struggling or was he taking up another cause, a cause for other people? And as you noted earlier, Erica, he's being celebrated by factions of people. Another aspect of this is the ingenuity here that they said when they had the press conference yesterday. I think it caught some reporters off guard, perhaps, that firearm we see in that video was a ghost gun. And Claudia King, I want to ask you about that. Certainly somebody who's adept at firearms, and they say he used a 3D printer, perhaps, to make this gun. Would you kind of take us to gun?
He could have hired someone. Who that time? He could have hired someone to make it for him if he didn't do it himself.
School a little bit. I had a couple questions. I was getting texts about this. People say, well, what are ghost guns and why? It goes back to the serial numbers, right? And the lack thereof. And would you kind of take us to school about some of the difficulties officers have in tracing these guns?
Absolutely. So when we think of a traditional ghost gun, it's exactly like you said. There's no serial number, there's no tracking on it. So you have no indication of the beginning of the life of that firearm to the end of it, where it came from. But now we have a whole new problem when it comes to the 3D printers. So you can literally print anything, including a deadly weapon, at home. These printers are actually not that expensive. They're not that hard to operate. And so this is a whole new problem that law enforcement is going to have to look at and think about in these printers, because, now this kid from Penn printed this gun at home. So there was no record of it. Nobody knew about it. There's no serial number on it, as you mentioned. So this is a new problem that technology has brought to us that law enforcement is going to have to now address.
Really great insight, Claudia. Thank you for that. You and Eric are standing by with us this hour. We're going to switch back to the trial that we're covering. Thank you for this discussion. And as we get more information on Luigi Mangione,
just for the sake of safety reasons, let's treat the name COL.T or SIIIG, whatever you need to do, just so I don't get in trouble. But I'm okay with you saying it. Yeah. Didn't realize I had a pinned message. My apologies. This is horrible. I'm trying to wrap my brain around it. And honestly, right now, I'm so sleepy. Let's see if this trial is going to get up and going. Yep, you betcha. How does that not surprise me? Why would that not surprise me? Everything goes up after something like this happens. Back in court. Come on. Okay, we're back in court. Court judge looking on the phone.
Everyone had a good night and had no problem with the court instructions. This time the state has rested. You've heard the testimony from the state, and now the.
But I agree with you, Zach.
Witnesses in this case, the chief, anyway. My daughter yesterday told me, so I look like Nick Saban up here. My coat.
I see where you ate.
Up here, my product endorsement, so I'm swapping Taylor grocery today.
Gosh, I would love a Dr. Pepper right now.
Who'd you call as defense's first witnesses?
So want a Dr. Pepper.
Walter. All right.
And I would just like to state for the record that this name was not revealed to record here.
All right, I'll be noted for the record. We'll see if it becomes relevant.
Yeah.
She was provided in discovery, Your Honor.
Okay. All right, have a seat and witness chair, please, ma'am.
I'm a pepper, you're a pepper. Would you like to be a pepper too? How about?
Might go in jail.
Yes, that's right.
What's it? My baloney has a name. It's me. My baloney.
Now,
has
while
a
we're waiting,
name.
I've
So
got
it's
D
me,
108 to introduce some evidence. Not going to be used this week.
Doublemint, spearmint, gum. I still remember all the Band-Aid, the spearmint gum Wigglies, I think it was. The Oscar Mayer bologna.
Left my hearing aid at home.
The pepper. I remember all those commercials still. That's sick. Ow.
We're gonna give you a bonus, Mr. Clerk. I mean, you're fixing their windows for us. And I believe it's working. You may proceed.
Thank you. Please state your name for the record, if you would.
Laura Reed.
Ms. Reed, where do you live?
In Greenville.
What's your address?
160.
Another Reed.
I want to direct your attention to on or about the July 7th, 2022.
Oh, Frito, yep.
To have a conversation with Jimmie Herrington pertaining to a move that would occur for you.
Yes, I did.
All right. And you recall the substance.
I'm going to try and get my wheelchair in here.
Mr. Herrington?
I texted him. He had moved some furniture for me before, and I texted to see if he was available to move some furniture from Batesville to Grenada and some other furniture from Grenada to Batesville, so a round trip.
It's a round trip. Do you know what your plan was as far as making that particular move? Had you solidified your plans on the 7th of July?
Yes, I texted him that Thursday, the 7th, and asked if he was available. I think he first offered maybe a later date. I asked for an earlier date. He said Monday, the 11th, and I said that was great.
Okay. Did you understand that? Did you have any other conversations with Timmy about the move after the 7th, either by phone or by text?
Yes. So we texted on Thursday, the 7th. On Sunday, which would have been the 10th, I confirmed with him and asked if he wanted to start in Grenada or Batesville, since we would, be going both places. He said Grenada and Monday morning at 8:30.
Okay. And at the time you had that conversation, that was the first time y'all had solidified basically when you would do that move. When did y'all finalize the move? When you knew for sure when he was going to do that move?
I mean, I guess I thought it was for sure on Thursday, but we actually confirmed it on Sunday.
All right. Give the court the benefit of what transpired as far as that move. Who showed up? Was he by himself? What vehicle he was in on that particular day?
Timmy showed up. He had his cousin Jordan with him. He had a white moving truck. What else did you ask? They came about 8:30, I think.
Where did they, when you said they came by 8:30, where did you meet with them?
At my house in Grenada.
Okay, where did you go when you left? After y'all met in Grenada, where did y'all go?
I went in my car. He and Jordan were in the truck, and we went to Batesville, and we made a stop at a storage unit, got a rocking chair, a few things there. We went to my in-laws' house in Batesville. In Grenada, we took the bed apart from my house, put it on the truck, went to Batesville, took the bed apart, swapped them out, and then came back.
Okay, when you say you took the bed apart, did you do that or did Timmy and Jordan do that?
Timmy and Jordan did it.
Ooh,
And
I'm taller.
Took it apart, pack it, put it together. Package it up. What happened pertaining to that?
Both of the beds had a lot of parts, and so I think I recall Timmy put the screws in smaller pieces in like a Ziploc bag and taped it to the rails for the bed at my house, and then the same thing for the bed at my in-laws' house.
You know exactly what type of tape he used to tape those items?
I don't.
Did you at any time help him pack anything or do?
Okay, guys, I'm much taller in the wheelchair. Oh, I will have to say, yeah, this feels better. Much better. There we go. Oh. Y'all, I can't tell you. Almost instant relief when I sit in this chair. Sorry I had to do that, y'all, but I just had to. Oh, so much better.
Do anything? He just moved everything.
And I'm high up.
Is that right?
I think.
Problem is getting me
It was him and Jordan
in
together.
close enough to get me where I need to be.
After you did that packing on that day, and what happened then? When y'all
I'll have to fix camera angles and everything in a little bit.
Grenada to Batesville, put the Grenada stuff in the Batesville house, got the Batesville stuff, brought it to Grenada, and then he set the bed up in my Grenada house.
What items did you pack in Batesville, out of the Batesville location to bring back to Grenada?
It was one of those beds, where like the one side will raise and the other, and it has the cords and all of that. We took that. We took, a rocking chair, several other items, but I can't recall exactly what they were.
How many times have you used Timmy to help you move items?
He has moved stuff for me twice, and then another time he came to an apartment where some furniture had been delivered and he moved it up the stairs.
What location was that?
That was my son's apartment in Oxford.
And do you remember about when that time frame was?
I want to say that was February.
Oh, I feel so much better in this chair.
All
I mean,
of the moves were in 2022.
And same procedure took place where.
okay, for those of y'all who are new and who don't know me very well, we've got some newbies on here. I am disabled and I love my office chair. It is super comfortable. However, yesterday I got my new wheelchair and it has an air cushion on it. And my back and my hips have been screaming for over a week. So that's why I just decided to try and switch into this chair because I am in so much pain. And it is weird because the moment I sit in this chair, it literally cuts in half. It is amazing. But they're expensive.
Basically, Timmy did everything, taking the beds down, moving boxes, stuff like that. He did all that. You basically stayed out of the way, fair statement.
Well, there was one time we were trying to move a couch up the stairs or down the stairs, something, and I think I helped, but yeah, Timmy handles it all.
Now, as far as You live in close proximity to the Herringtons, correct?
We live on the same street, probably 3 houses apart, but across the street.
How long have y'all lived across from each other or down the street from each other?
15 years, I think.
Now, Ms. Reed, have you ever seen activity in the front yard of the Herringtons, as far as yard work, or equipment out there, things of that nature, loading stuff? I'll rephrase your question. Give the court and the jury the benefit of your observations as to activity
Definitely
seen pertaining to Jimmie Herrington, work related.
My house is past their house, so anytime I go home, I drive past their house, and their family has, I think, what appears to be a yard maintenance business. You know, there will be trailers with stuff. They have a charter bus business, so there's sometimes stuff with that. Their church, I know they have a big music thing that they do with their church. So there's often trucks and equipment and lawn stuff.
The box truck that Jimmie used on the move in July 12, 2022, prior to that date, had you seen it on occasions at the Herrington residence?
Yes.
How would you classify that, regular or otherwise, on a regular basis?
I mean, I haven't committed it to memory, but I would say it wouldn't be unusual
To see it there?
Right.
Would it normally be parked? Where would it normally be parked?
I guess it would depend on how many cars were in the.
Have you seen it parked in any location in front of the house?
Yes.
Courtroom door.
wow, that totally woke me up.
Good afternoon, Ms. Reed. Just so I'm clear, the move that you're referring to, you set it up with him on the with Timothy Herrington on the 7th?
Yes.
Of 2022, okay. And then the actual move took place on July 11th, 2022?
Yes.
Okay. Are you aware of what Timothy Herrington was doing on July 8th, 2022?
No.
Do you have any knowledge regarding Jay Lee or anything of that nature?
No, ma'am.
Are you aware of if, you said you lived by them for 15 years, correct?
Approximately.
Okay, and in those 15 years, have you seen their children and interacted with the Harringtons and their kids often?
Yes.
Okay. Are you aware if Timothy Herrington ever had any boyfriends?
I'm not aware of any.
Are you aware if Timothy Herrington is gay?
I'm not aware.
No further questions.
No.
Right, next will be fine excuse.
She made it.
Thank you for being here, Ms. Reed. You're free to go. You're welcome to go, whatever you like. All right, everybody good on the
That
board?
was nice, short and
So,
sweet. Thank you,
who
ma'am.
you call his
We
next
appreciate you, ma'am. Good job, ma'am. Thank you very kindly, ma'am.
Judge, the defense next call, Mr. Quentin Love.
Quentin Love.
Quentin Love.
Somebody show Quentin Love. here.
I am like not used to this sitting up so high. My feet, gosh, this is comfy. We're going to see how long it takes for me to get uncomfortable, though.
Judge. you please
I
state your name for the
know.
record?
Jeremiah Love.
And
Thank you
Jeremiah,
for
is
dressing
that your full
appropriate
name?
for court.
Quentin Jeremiah Love, my full name.
And you prefer to go by Jeremiah?
Yes, sir.
Is that all right if I call you
Jeremiah
here today?
was a bullfrog. Sorry.
So, Jeremiah, would you please, without giving your address, tell the court where you live?
Grenada, Mississippi.
And Jeremiah, how long have you known Timmy Herrington?
All my life.
And from what basis have you known him your entire life?
Since we grew up together.
Do y'all have any relationship together? Are y'all related?
Yes.
And what is your familial connection? What is the family relationship?
My grandmother and his grandmother are sisters.
I'm sorry?
My grandmother and his grandmother are sisters.
Okay. So, Mr. Love, during your time knowing Mr. Herrington, have you ever been involved in his moving company?
Yes.
What did you do in connection with his moving company?
Basically help him move all the big stuff. Basically all that, move all big stuff.
Okay, so you would assist him in some of the moves that he did with his moving company?
Yes.
How would, I understand, did he have a business partner in that moving company?
No.
He didn't have anybody else that was involved in his moving company?
No.
Okay. So how would he contact you and let you know that he needed help on a move?
You know, call. Either you call or you text me.
Okay, and what would the gist of that conversation be?
He'll normally ask me if I'm busy, don't want to help him move stuff. I'm like, I help my woman.
Okay. Did he call you every single time he had a move, or just when he needed extra help?
Just when he needed extra help.
And primarily, what areas would he call and ask for you to assist him?
Basically in Grenada.
Okay. Did you ever assist in moves anywhere else or just in the Grenada area?
I helped him one time in Oxford and from Jackson to Texas.
Okay. So one time in Oxford, you said once from Jackson to Texas. Beyond that, the majority of the time that you assisted was in Grenada?
Yes.
Did Timmy ever contact you requesting help or assistance in doing any other types of work aside from moving business work?
Yes. He granddaddy got rental property. I always help him cut around, cut grass and stuff.
Can you speak a little bit slower and try to just enunciate a little bit?
Oh, my bad.
So, what other work would Mr. Herrington request your assistance in?
When granddaddy had rental properties, so I always help him cut grass.
His granddaddy had rental properties?
Yes.
Do you know, in general, where some of those properties were located in Grenada?
Yes.
And so where would that be?
Basically in town. You got some on Pecan, Carbon Road. Basically got houses like everywhere in town.
Does he have some houses in town?
Yes.
Does he have some houses north of town?
Yes.
Yes, it is.
South of town?
Yes.
Right now, I'm loving it. Just saying.
So, Mr. Love, what types of work would y'all be involved in doing in relationship to these rental properties?
Cutting grass or picking up trash.
Was there any other general maintenance that was done in these properties?
Cleaning out the rental house too.
And were you around when Mr. Herrington would be told to do this work, or is this communication he would have had with Mr. Herrington beforehand?
Communication.
When you guys would be involved in doing some of the moving business, what vehicle did you normally use to do the moves?
His box truck.
Is that a white box truck?
Yes.
Did you ever use any other vehicles
in relation to the moves, or was it just the box truck?
We use some of his granddad got handicap vans, so we use some of the handicap vans.
Would that be for smaller moves, or was that?
Yes, small moves.
So anytime you had a large move, you needed to use the box truck?
Yes, sir.
Did it ever come to your attention that Mr. Herrington would use the box truck for other reasons aside from just using it during moves?
Yes.
And what types of things was he using the box truck for aside from moves?
On here are like little dirt rides in there, so we always have a broom on the back of the box truck, and we always sweep it off before we have to do our next move.
Okay, could you repeat just the first part of that?
I said, we always have like little dirt rides in there, so we all have a broom on the back of the box truck. We always sweep it off before we all make our next move to do movement.
Okay, you said that there would be dirt in the back of the box truck, and you'd have to use a broom to sweep it out?
Yes.
And what did that mean to you when you would have to clean out dirt or debris from the back of the box truck?
What do you mean by that?
Well, I asked the question, when he would use the box truck, would he use the box truck for other things?
Oh, yeah.
Your response was that sometimes there would be dirt in there and we would have to use the broom to sweep it out. What did the presence of the dirt in that box truck that you had to sweep out, what did that mean to you?
They did other stuff beside, move around.
Would you see Mr. Herrington driving the box truck?
Yes.
Would you see him driving the box truck at times when he was not engaged in a move?
No.
So you never saw Mr. Herrington drive the box truck to any other locations?
No, sir.
When was the last time that you remember driving the box truck?
The last time we were moving was moving my sister back home from Memphis, Tennessee, back to Grenada.
And when was that in relation to the time that Mr. Herrington got arrested?
I think before he got arrested. I'm not really sure the date was.
Mr. Love, have we previously discussed aspects of your testimony at my office?
Yes.
When we were at my office, I showed you a photograph of a wheelbarrow at that time. Do you recall that?
Yes, sir.
Describe, as soon as I showed you that photo, what did you recognize that photo to be?
The wheelbarrow.
And where did you recognize?
Y'all, I'm enjoying this. The dude is asking the correct question. Why? Can we listen to this attorney? Can we just get rid of the other attorney? I just want to hear this one. This one is simply amazing. Absolutely amazing. Love, love, love him. I'd rather listen to him all day, and this is how you do it. Dude, take example and learn.
Recognize that wheelbarrow from?
In his daddy's garage.
You're saying when I showed you the photo, you recognize that wheelbarrow as being the same wheelbarrow that came out? You recognize that photo immediately?
Yes, sir.
And I believe you just said, but where was the wheelbarrow that you knew of to be located prior to seeing that photo?
In the garage.
Now, I want you to look down right here at the stand up if you need to. Is this the wheelbarrow that was depicted in that photograph?
Yes, sir.
Is this the wheelbarrow that you remember being in Mr. Herrington's garage?
Yes, sir.
Is this wheelbarrow in essentially and materially the same state and condition as you remember it previously?
Yes, Your Honor, no foundation to when he last saw it, how he last saw it.
I think he's testified sufficiently for that question. You may answer the question.
Mr. Love, is this wheelbarrow in materially and substantially the same state and condition as the last time you saw it?
Yes, sir.
Attend to the witness.
It's been mentioned before. That it has.
Mr. Love,
That said,
when did you start working with Timothy Herrington at the moving business?
Doing COVID.
So, like 2020, like when COVID first started?
Yes, ma'am.
In 2022, were you working for him or with him? Did he hire you, or were you working together, or was he hired you to pay him?
Working together.
Sorry. So you were like a hired employee sometimes?
Yes, ma'am.
Okay. And in 2022, you were working?
Yes, ma'am.
Okay. In July 2022, were you working with him?
Oh, this is good.
July
Yes.
22? No, not in July 22.
Okay, so in July 2022, did you ever see him doing moves with the box truck?
No, ma'am.
And you also stated on direct just now that you only ever saw him using the box truck when he was doing moves, right?
In Grenada.
Gotcha,
So
bull
you
butter.
only ever saw, that's in Grenada when you saw him doing moves in the box truck, he was doing moves. Would that be correct?
Yes, ma'am. In Grenada, I be with them.
Okay. You said that you've known Timothy your whole life,
Yes,
right?
ma'am.
Y'all grew up together?
Yes, ma'am.
Would you say that y'all were close?
Very close. We're like brothers.
Okay. So in your time knowing Timothy, do you have girlfriends?
Yes, ma'am.
Okay. Did he have boyfriends?
No.
Did you know that he liked men?
No.
Did he ever tell you he liked men?
No. I don't judge.
Yeah. I understand you don't judge, but did he ever tell you that he liked men?
No, ma'am.
And
Didn't talk about
said
it.
that you've seen that wheelbarrow before, right?
Yes, ma'am.
And it was in the garage of
They
Mr. Harrington's house?
Yes, ma'am.
And have you ever seen Timothy using the wheelbarrow?
We both have.
Okay, so when you use it, it looks like it's clean now. There's no dirt in it. Was there dirt in it when you used it?
When we always use it?
Yeah.
Yes.
Okay. So dump the dirt out, you rinse it off, and put it back, right?
And half the time be with like excess grass too. Excess grass. Excess grass, like
Excess
dead
grass. I'm
grass.
sorry.
Yeah.
Okay, and you would rinse that off and put it back
Yeah, ma'am.
to keep it in a nice condition, right?
Yes.
No further questions.
All right, ready, ready?
Mr. Love, you would only, would Timmy call you every time he needed help?
Yes, sir.
So were there moves that Mr. Harrington did when he didn't call you?
No. Even Grenada wise, no.
Well, I'm saying, you were not a partner of this business, were you?
No, sir.
Okay. So, is it your testimony that you assisted on every single move he did in Grenada?
Yes, sir.
Okay. You said that sometimes there would be dirt or debris in the back of the box truck that you'd have to sweep out. During the course of your moves, was it common to track a bunch of mud and debris in the car in the back of the box truck during the course of a move?
Yes, sir.
Thank you, Mr. Ruff. No further questions.
All right, may this witness be found excused? This witness be, you're welcome, you're free to stay, or you're welcome to go, whichever one you like. Thanks for being here. I need to take up another matter not related to this, just for 1 minute anyway, okay? Come on back.
Wow. Okay, Your Honor. A little break. Give me a break. Break me off a case that kick up bar. Oh my gosh. My pain has gone down from an 8, 9 to almost a 0 the moment I got in this chair. But let's see how long I can sit in it. My problem is it's not easy to hop up out of this thing real quick. I love it when people walk in here and they don't know idea what we sell. You people walk in and think we're a tea house, but we are going to be selling tea leaves and coffee, but we're not a tea house. Not a tea house. They think Guadalupe leaf means tea. Can mean a lot of leaf. Let me go back and look at some of y'all's comments while I was getting my chair in here. Yes, everybody, oh my gosh, I got to do this. My brain has been mush lately. I'm going to welcome As the Gavel Drops as partner to the Ada K channel. Thank you so much for all your court documents and your mods and all your efforts to keep us updated as to the happenings in trials that are very popular at this time. Right now, they have over 500 cases that they are currently following. So if you love to read court documents and dive in for yourself, go to their Discord, As the Gavel Drops. Make sure to verify your account in order to access the documentation. Thank you, As Gavel Drops, for being our partners. We appreciate you tremendously. Somebody wanted to see my swoop. That's my swoop. Puppers. Is there anything breaking since that guy was in court? Anything new? Any more videos? Oh my Lord. Somebody wrapped up a toilet in Christmas paper. Dude, if you're going to get a new toilet for your home, please don't wrap it up like it's a gift for your wife. She will not love you anymore for it. A guy got his wife a toilet and replaced the toilet. What? Oh, we got to do this. We're going to pause that. We're going to play this. Y'all. It was today.
Of State of Nevada versus Diablo Delone Redden, case number C24.
This is the guy that jumped over the bench and attacked the judge.
Counsel, who's present, please identify yourself for the record.
Good morning, Your Honor, or good afternoon. Liz Mercer and John Giordani for the state.
Good afternoon, Carl Arnold for Mr. Redden, Your Honor.
And I see that he's present and in custody. Okay, this is the time set for sentencing. Are we ready to proceed? We are, Your Honor.
Your Honor, I just want to make sure that you have received our sentencing memorandum with Dr. Paglini's report dated August 1st, 2024. Karen Springer's affidavit dated December 5th.
Throw the book at him, please.
Dr. Paglini's current update dated December 5th.
Yes, they were very lengthy, single space. I even read them, Mr. Honor.
I knew you would, Your Honor, so thank you.
Okay.
I can't fall asleep in this one. I'll show you why later.
Right. Mr. Redden?
Yes, hi.
Okay, I need you to stand, sir.
Okay. Sorry, I feel a little nauseous.
Yes, ma'am.
Are you okay?
Yeah. I'm embarrassed.
Okay. All right, sir, I have your guilty plea agreement or memorandum here in front of me, which, as you know, was filed in open court on September 5th of 2024. I canvassed you on this guilty plea memorandum. You signed it, and you answered all of my questions. I am adjudging you guilty, but mentally ill, to committing the following crimes. Count
Mentally
1,
ill?
Attempted murder, victim 60 years of age or older, a category B felony in violation of.
I have to. Guilty but mentally ill. Are you kidding me?
NRS 200.010, NRS 200.030, NRS 193.153, and NRS 193.167. Count 2, battery on a protected person resulting in substantial bodily harm, victim over 60 years of age or older, a category B felony in violation of NRS 200.481, and count 3, intimidating public officer, a category C felony, in violation of NRS 199.300. Count 4, battery on an officer resulting in substantial bodily harm, a Category B felony in violation of NRS 200.481. Count 5, performance of act or neglect of duty in willful
I
or
know.
wanton disregard of safety of
I'm
persons or property,
surprised.
resulting in
That's not always
substantial
easy to
bodily
get.
harm or death, a Category C felony in violation of NRS 202.595. Count 6, battery by prisoner, a Category B felony in violation of NRS 200.481 subsection 2F, and count 7, unlawful act relating to human excrement or bodily fluid, a Category B felony in violation of NRS 212.189. Does the state have anything to present?
Yes, Your Honor.
All right.
Thank you. Your Honor, before I begin my argument, I would note that he has 16 days credit for time served, and that is because he's been under sentence of imprisonment in the case that he was sentenced on in front of Judge Holtis when the events in this case took place. Additionally, the state is requesting a total of $61,318.41 in restitution.
Okay, $61,318
and 41 cents in restitution.
Snap.
And it should be paid to CCMSI. That's the company that administers the workers' comp claims for the 3 officers involved in this incident that sustained injuries. As the
Yeah, I
court's
think
aware,
one
we
had
have
to
a
have
very
shoulder surgery.
lengthy and detailed sentencing memorandum.
I know, I read that too.
So I'm not going to spend a whole lot of time regurgitating everything in there, but there are some things that I want to point out for the court. Initially, as indicated in our sentencing memorandum, we are asking for significant prison sentences as to each course of conduct, and we're requesting that as to each course of conduct, the sentences run consecutively to one another.
But did you have some run concurrent? I'm looking at page 3.
So the counts would run concurrently as to the victim, but consecutive between the various victims, essentially.
Right.
And so it's the state's position, Your Honor, that the defendant's very lengthy criminal history, his demonstrated lack of impulse control, and his inability to completely accept responsibility for his conduct, as well as the egregious actions in this case, warrant such a significant sentence. I would note that his criminal history dates back to 2011. In each event, as you read through the reports, they all stem from his poor impulse control issues. And prior to this case, he was convicted in 12 other cases. They all involved some level of violence. In 9 of the 12 cases that he committed new offenses while charges were pending. And the longest that he went without reoffending was a period of 2 years and 2 months. The only time that he did not commit new crimes was when he was in custody, Your Honor, and subject to detention. I point these things out because it is obvious from his demonstrated failure at supervision that probation is completely inappropriate for someone like Mr. Redden, and he should be detained for as long as possible, because the only time that the community is safe is when he's in custody.
Going to attack her?
He has
Is he going to attack her now?
demonstrated that he's incapable of being rehabilitated or reformed.
He's getting irritated.
When you look at his record, he was actually in mental health court for a total of 5 years. And even after that 5 years, he committed 2 more violent offenses. One with an attempted home invasion and committed in September of 2021. And then in April of 2023, he committed the assault with deadly weapon that was dealt down to the attempted battery, resulting in substantial bodily harm, for which Judge Holtis sentenced him. And then in January 2024, when he showed up for sentencing in that case, he committed the horrific crimes in this case. Additionally,
I can't believe
as
he
the court
got
is aware,
over the bar.
You were provided
and
2 expert
whatever.
reports, one from Dr. Rowley and one from Dr. Paglini. Both doctors found that he was not suffering from any sort of delusional disorder at the time that he committed the crimes in this case. Dr. Rowley noted that he has problematic insight and judgment, but noted that those issues relate to personality issues and not his mental illness. And that in Dr. Paglini's report at the bottom of page 17, he noted that he has no insight or self-awareness pertaining to his violent history. On page 26, page 34, he noted that Mr. Redden's impaired judgment is based on personality dynamics and not psychosis. So Mr. Redden was perfectly aware of what was going on at the time he committed the crimes in this case. I think that what you notice pretty glaringly when you look at his criminal history is that Mr. Redden has repeatedly failed to recognize that he is the common denominator in these cases. It is his actions that end him up in situations such as this. It is not him being victimized by other people, it is his conduct. And until he accepts responsibility for reforming his conduct and for his poor impulse control, he's really incapable of being rehabilitated, because if he doesn't believe that he's done anything wrong, what's the incentive to improve? As to the facts of this case, Your Honor, Mr. Redden cannot be permitted to retaliate against the sitting judge and officers of the court when he's displeased with the outcome of a criminal case. Judges need to be free to make the rulings that they believe are appropriate based upon the information presented to them. And due to his extreme conduct in this case, a heavy sentence is warranted, Your Honor. It is my understanding that Judge Holthus does not wish to address the court personally, but she has prepared a statement that Mr. Giordani will read to the court with the court's permission. We would ask that it be read last, as it is essentially a victim impact statement, which would statutorily be provided to the court last.
Thank you. Darnell.
Your Honor, I'll let Mr. Redden speak first. He wants to address the court.
Oh, here we go.
Susan H. Johnson. I don't understand why the state is like really going after my character. I mean, I've always had problems since I was a little kid of like psychosis and being in big crowds and always feel like my life is in danger. I didn't know, being a young person, even in middle school, elementary school, knowing that like I fear for my safety. I'm just being me, going to school, growing up, trying to do the right things. I never get tired of trying to do the right things. The state just said that I have no remorse. Like, I feel like Judge Johnson, she doesn't know me. I understand she's doing her job. I'm not mad at her for that, but I know that I'm not a bad person. And I'm thinking, like, even she knows that, but I'm sitting here like she's doing her job, you know? And I believe that you all know that I'm not a bad person. I'm not an evil person. When I came to court on January 3rd, 2024, I was listening to music. I was in a good mood. I had a stable place to stay. I was trying to get a job. I did not catch any new charges. I'm not a bad person. I don't understand why the state is trying to prove me as a bad person. I understand they have a job to do, but this is just, it's not right to me, you know? I'm not an evil guy.
Getting agitated.
I just keep going after me. I see.
He's getting more agitated. If I was those police officers, I'd start scooching forward.
Spirits. I hear voices. I've been going through this for over a decade now, really since 2012, you know? And I just feel attacked or just not safe since I was a little kid. And me growing up, I didn't know that I had these problems. In 2022, I came to prison for the first time. I accepted responsibility for my actions when I did what I did. I committed a crime in 2020 of December. It was 4 years ago. I paid my debt to society. I got out thinking I'm gonna get work. I was really sick and ill. I was very malnourished. I don't complain about things. I don't point the blame when people have done me wrong. I still treat everybody right. And the state just stated that I have no remorse and they feel like I'm a bad person. I just don't understand why are they coming after me like this. But I understand they have a job to do. When I came to court, I know for a fact, Judge Johnson, I met Judge Holthus in 2023 of October. And you know what she told me when she revoked my probation? She said, Mr. Redden, I hope you get the help you truly need. I said, thank you so much. And I meant it. I know for a fact I'm not an evil person. I think all of you guys know that, you know? But I'm not going to use stuff like me being on camera for
Do we though? Do we know that? I'm not too sure about that, y'all. What are your thoughts? Do we know that?
For my
That's what I
actions, you
saw.
know, but I know for a fact that I cared about Judge Mary Kay Holthus's well-being. When I left my house that day at 8 Rose Circle, I left
Oh
my
my gosh,
keys
y'all.
to my apartment, to my family, you know, and I got in the car and I came to court doing the right
Throw the
thing.
book, Your Honor.
I gave up everything, like in case I don't get probation. I was like, well, at least I know I tried. And I'm sitting here talking to Judge Holthus, Miss Johnson, and I swear I started hearing voices in 2012, really in 2014. I'm gonna make a long story short, but I just want to get the facts out because I don't want the state. I understand they have a job to do, but I'm not a bad person. I'm not an evil guy.
Okay,
And
enough.
but
Stop
I
your
came
client.
to court and I'm in a good mood. I'm listening to music on my phone. Oh, whatever. I remember
Okay.
I got about to hug
He is a sick man.
my mom, my foster mother who raised me since I was 11 years old. I hugged her as like, just in case if I don't depress. You could see it in the videotape yourself. I was in a good mood. I don't want to be known as a person who has mental illness because those people get attacked. I've heard so many people who have mental illness commit suicide and kill themselves and commit things that they really don't mean. I hope I don't have mental illness. I try not to have mental illness, you know. I don't want to be known as a person who has mental illness because they get attacked.
Time
You
is
know,
up.
so I try my best when I'm going through all these problems. Since I was a little boy, like I told you, I
Yeah,
didn't know I had these problems until 2 years ago. I was sitting down in prison and I had this dictionary. And I was like, oh, that's what that word means. That's what that really means. I didn't know that. Oh, stuff has a deeper meaning. You know, like, wow, I never could think like this. I was in prison with nothing to do. I did a 12 to 30 months. I did 15 months total, and I cleaned up my sentence. I paid my debt to society, and I got out as a good, productive member of society. I didn't know and didn't want to believe that I had mental
Every time he says I'm a good person, I want to add 5 years.
problems. You know, I started seeing spirits November 2022. I'm not making excuses for my actions, but I'm saying I'm not a bad person. And I know that I did not intend to kill Mary Kay Holthus. I know I cared about her well-being, Judge Johnson, you know? And I came to court that day and I was talking to her and I told her I never stopped trying to do the right things. I wasn't pointing like, oh, this person did this to me. I deserve a chance of probation. Like, this is not fair. All I see was red and all I heard her say, oh, this, like she said, and I finally watched the whole video. I was standing here in the courtroom with all of you guys, and I finally saw the entire video, Judge Johnson. I'm like, I can't believe this. And I wasn't even mad at Michael Lasso. I was like, I commend him on doing for what he did, and everybody in the prison trying to make me hate him and hate the judge, and I'm still trying to do the right thing that happened to me. So I know myself, but
Your Honor,
you know,
I can't.
that's all.
Thank you.
can you sit during my,
Sure.
And Your Honor, again, I hear the state in that they're saying it's a lack of impulse control. I agree with that. However, he's adjudicated guilty, not guilty, but by mental illness. And so, bottom
But I don't want
line,
to be known as
his
mental.
ability to control his impulses are vastly different from my ability, from Mr. Giordani's ability. He does not have the same ability to control his anger, what he's going to do, because as you saw in Mr. Dr. Paglini's report, from day one, from birth, he has had this mental illness based upon his mother's drug use at the time of her pregnancy, the stuff that he saw during him growing up, going through different households, going to a stable home in his foster parent, but he was still unable to comply with just normal behaviors. And all of that should be taken into account. I think this case starts
Yeah, he
again in
80s
April
man.
of 2013. The 18th is when he was arrested after going after his brother-in-law with the baseball bat.
Okay, y'all want to zoom
Basically,
in?
again, this was during a period of time where he wasn't doing his medication. He was off his meds. He's going through his paranoid disorders, whatever those that were outlined by Dr. Paglini. And
I can't.
he's eventually sentencing back on the medication affidavit to get this medication.
I'm sorry, y'all.
For 2 months after his release, which again is an occurrence that I haven't seen before, he's unable to get that medication. Of course, he's going to slip back into the same impulsive behaviors that he had before. Of course,
That's why he needs to be an
slip
institution
back
that can
and not
ensure he
being
gets
able
the
to
medication, you
suppress
know?
the thoughts and delusions that he was having. He went back right to what we saw in August 2023. And so again, that should all be taken into consideration. The state is asking for consecutive time. Part and parcel, his mental illness continued from the 2023 incident all the way until today. He was never released after sentencing in January 2024. We're asking, and I'll get to how much time, but we're asking that it all be run concurrent with his sentence that was received from Judge Holtis, the 1948, to whatever Your Honor believes is appropriate today. And the reason why we're asking for this to be concurrent is simply because he didn't have the chance to get out. He didn't have the chance to rehabilitate himself. He didn't have the chance to demonstrate to the court that, okay, he learned his lesson.
Yes, do you?
He was still under the state's control during the time of his sentencing. The same state that we forgot to inquire prior to his sentencing, whether he was under his medication, the same state that didn't provide him with his medication, the Mojave Health Clinic, you know, being it during the holidays, was unable to give him an appointment. I believe that this case has shed light on people's mental illness and what we have to do to, number one, bring them into court and understand what they're going through. And I don't think the answer is just throw away the key, give them a whole bunch of years. That benefits no one. We understand that a message has to be given. Since he's been on his medication, as you see him today, Your Honor, he's being courteous, he's being compliant, and he's deeply remorseful about the events and what happened that day.
All right.
What I haven't shared with anyone other than my staff, and me and Mr. Redden talked about it. The first time that he saw the entire video was right here in court during the presentation of evidence. I was sitting right next to him. His reaction was very visceral. It was almost like he wanted to throw up. He called himself a monster. He did, Your Honor. That's me. I'm a monster. I can't believe that I did that. I did not mean to hurt that woman like that. I can't believe that I did that. That's what he said sitting in the same exact chair during trial. I believe he just, like he said, he doesn't have any specific recollection of coming over the bench, but when he saw it, he was deeply remorseful. He was just shocked about how he could act that way. And I think, Your Honor, all that should be taken into consideration. He understands the difficult position that you're in. We talked about this at length. I told him, there's just no way you're going to be granted probation in this matter. That was spelled out to him. Also, what was spelled out, there has to be a message that, you know, you can't come flying over the bench because you didn't get the sentence that you wanted, or you're upset with the sentence. There has to be protection to your honor, has to be protection to the prosecutors, has to be protection to everyone in the courtroom. And so that message has to be sent so we don't have the next Joe Schmo that gets upset and takes it out on court staff or anybody surrounding them. He understands that. And with that understanding, he knows that he has to do some time. What we're asking for, Your Honor, is a 4 to 11 year sentence. How we got to that was a 2 to 5 on counts 1, 2, 3, 4, and 5, all to run concurrent. Consecutive to that, and by statute, counts 6 and 7, we're asking for a 2 to 6. So the total of that and the count 6 and 7 are running concurrent with each other. So, and we're asking also that be concurrent with his current 19 to 48 sentence. So we're asking for a 4 to 11 year sentence. I think that's sufficient considering, number one, his mental illness that he was under, his inability throughout life to control his actions based upon that mental illness. The state and our failure to be able to recognize mental illness and what we should do in terms of addressing it, getting him the type of help, and not just throwing him into prison, but figuring out ways, which we're not equipped with, but a psychologist would be more adept to figure out how to help these individuals and give them a life plan, whatever it takes, so when they do get out into society, they're able to comply and have appropriate behavior. As you saw from Ms. Springer's affidavit, this was an individual, coming off of his meds that still wanted to comply. He had a living arrangement. He was trying to get to his appointments. He even obtained a job at the Teamsters union and received a dispatcher job, while he was waiting for sentencing that day. This is a person that can and would be able to do it given the appropriate help from a psychologist and mental health counselor. So we're asking again, Your Honor, considering all the information that was provided to you, considering the gravity of, his mental illness and his life, that you sentencing to what we recommended. And with that, I submit.
Thank you.
On behalf of Judge Holtis, Judge, the impact on me and my family has been substantial, both mentally and physically. The impact on my professional family has also been significant, both mentally and physically, especially in the case of my Marshal Shane, who suffered horrific injuries trying to protect me. To him, I am incredibly thankful and so very sorry. But for 6 men, grown men, half of whom were unarmed, I would not be here. To them, I owe my life and will forever be grateful. For years, the system has tried unsuccessfully to help the defendant conform his behavior and limit the danger he presents. Instead, his behavior has escalated to this: trying to kill me as I sat, just doing my job, in a courtroom surrounded by guards and court personnel. He made a conscious decision to kill me and made every effort to succeed. If he had his way, he'd be facing a sentence of life without the possibility of parole for murder. It is likely no surprise that for me, as well as his future victims who may not be as lucky, I wish for the maximum sentence allowed.
Go girl.
Were there any other speakers?
No, we'll submit it, Judge.
Wow.
Mr. Redden, I am not going to run any sentence that I impose today concurrent with that issued by Judge Holtis. In my view, you committed separate crimes, and that
Yes.
results in separate sentences.
Thank you.
So it's not going to run concurrent to what she has previously issued as far as a sentence. All right. With respect to this sentence, first of all, there will be a $25 administrative assessment fee, a $3 DNA administrative fee. And Mr. Arnold, were you appointed or were you retained on
No,
this?
I actually did this case pro bono, Your Honor.
Okay. There will not be any DNA testing fee because frankly, given your history, it's already been taken. Your actions on that day, you know, it was not just retaliation or an attack on Judge Holtis. It was also an attack on the judiciary. And I'm mindful of that. And while there is no question that you've got some mental illness issues, which is why you pled guilty but mentally ill, but there was no doubt by these doctors that you knew the difference between right and wrong. You did what you did. So this is what I'm going to do with respect to the sentence. Okay, with respect to count 1, sir, I'm going to do this. The minimum term that you would serve would be 8 years, and the maximum term will be 20 years. Plus, there will be a consecutive potential maximum term of 8 years to 20 years. So with respect to count 1, the minimum term that you will be serving combined would be 16 years, and the maximum will be 40 years. With respect to count 2, the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. With respect to the consecutive enhancement, the age enhancement, the minimum that you will serve will be 4 years, and the maximum will be 10 years. So with respect to count 2, the minimum term combined will be 8 years, and the maximum will be 20 years. The term that I impose with respect to count 2 will run concurrent to count 1. With respect to count 3, the minimum term that you will serve will be 2 years. The maximum term will be 5 years. That term will run consecutive to count 1. With respect to count 4,
I'm losing track, y'all. Anybody keeping up?
the minimum term that you will serve will be 4 years, and the maximum term will be 10 years. That also will run consecutive to counts 3 and counts 1. With respect to counts, well, wait a minute, yeah, okay. With respects to counts 6 and 7, sir, the minimum term in both of those counts will be 4 years. The maximum term will be 10 years. However, those will run concurrent to each other.
I'm confused.
So I'm not following what your attorney has suggested. I'm following what the state has suggested. Did I catch them all?
I believe you skipped 5.
With 5? Correct. Sorry about that. Okay. The sentence with respect to count 5 will be a minimum term of 2 years, and the maximum will be 5 years. That will run consecutive to count 4.
And then counts 6 and 7 are concurrent to each other and concurrent to.
And consecutive to, well, wait a minute, that was, count 6 was with respect to Officer Brandon, right?
Officer Boo, you're on
Officer
6 and 7.
Boo, that will run consecutive to counts, the other counts. See if I can.
Minimum, well, because they're doing one count, they're not
with respect to count
congruent,
6,
they're
it's to run
consecutive.
consecutive to counts 1, 2, 3, 4, and 5.
Right.
And then as far as count 7, it's to run concurrent to count 6.
Correct.
Thank you.
Could you give me the advocate, please? When you get a chance, you need a second?
Yes.
I'm sure somebody will break it down.
26 to 65.
I'm going to verify.
That's a lot of years, y'all.
And Your Honor, as to the restitution?
There will also be restitution to the victim.
Thank you, Judge.
I still keep coming up with 36 on the top. Maybe it's 14. So here on count 1.
This, counts 1 and 2, that's 16.
Yes.
That's 8. And 8 goes into 16.
Yeah, so here I have and then we have the added 8 over 20. The average is 1640.
Right.
And then here.
I think he's going to have to serve at least 15 years at least, if not more. His life was 60. Yeah, he's there for a while.
Count 2 will run concurrent to count 1.
So let's recap. I wish they'd all get a mic. He's explaining it. So the earliest he'll be able to get out of parole is what, 10 years? I think.
How many months did you have on the bottom? 120?
We had 26 years to 65 years aggregate.
And I see 65.
Okay. And there will also be restitution to the victim, payable to the victim in the amount of $61,318.41.
61,000.
SI.
Yes, Your Honor.
And what does that stand for?
I don't know. I apologize, Your Honor.
Okay, could you do me a favor
I can
and
look
let
it
me know what that is? Because we need to put that in the judgment of conviction. And we need to give this gentleman credit for time served.
16 days.
60 days?
16.
1
days.
6. 16 days time served. Whoop, whoop.
Okay,
Thank you.
Thank you, Judge.
okay, thank you.
Y'all, I'm going to get us back on the other trail. My coffee distributor just walked in. So why don't we get back into this trail? I need to go say hello to her. I shall return. Thank you for your patience. Our coffee sponsor. Yay. Be right back.
Okay. That's all right. Where you at? Oh, yeah.
Bishop, did Tim act independently of y'all's conversations, keeping up with the affairs that you told him to do over the years? Did he have to have instructions?
Hang on a second. Hang on a second.
He opened it up.
Hang on a second. What's the objection? Rephrase your question.
Did Tim act independently of you and his responsibilities that you gave him?
Ask him how he acted rather than.
How did he carry out his responsibilities? Did he need direction from you?
Ask and answer. Cover on direct and cross.
I'm gonna let him ask it.
Yes, he did carry out his, my instructions and he done it. I would give him several instructions and he would do it on his time.
Whenever he got time to do it. Was it necessary for you to call him on a regular basis for him to carry out those responsibilities? Now, Bishop, did you really ever have any conversations with Jimmie about his sexuality at all?
No.
Thank you.
May this witness be finally excused.
You can be.
Mr. Herrington, you're free to go. You're welcome to stay in the courtroom, whichever one you'd like to do, okay?
Suspended rest.
All right. Ladies and gentlemen of the jury, let me ask this. State, don't have any rebuttal? I'll give you a minute to think about it. I want y'all, I got some more business I gotta do. Don't go far, and I'll get some more class. Go to the jury room this time. Don't form or express any opinions. Don't talk about the case. That door closed? All right, it is now. Mr. Harrington, I'm going to direct these comments to you again. If you'll recall at the break not long ago, I advised you that you had the right to testify in this case if you wanted to. If you do choose to testify, you'll be subject to cross-examination. If you choose not to testify, the jury will be instructed the fact that you chose not to testify could not be used as any evidence of that you were guilty of any crime. I asked you at that time to be consulting with your attorneys and for you to make a decision. It would be your personal decision. It would not be your attorney's decisions, but your decision about whether you wish to testify or not testify. Have you had an opportunity to consult with your attorneys about that issue? Have you reached a decision about the decision whether you wish to testify in this case or wish not to testify? What is that decision? Okay, and you've consulted with your attorneys in that regard. That way, is that your understanding, Mr. Horan, as well?
That's correct.
All right, all right. And at this time, the defense is rested. Is that correct?
That's correct.
I'll ask the state, does the state have any rebuttal witnesses?
No, Your Honor.
All right, so we've heard all the testimony. All right, if you wish to renew your motion at this time, you may do so.
Your Honor, in the position that Move again for directed verdict or in the form of a peremptory instruction to instruct the jury to find the defendant not guilty.
All right. I don't think there's been any significant change in the testimony from the time the state rested and the time the defense rested. For the reason stated in the record, at the conclusion of the case states in chief, the court is going to overrule your motion for directed verdict. How long is it going to, who all has filed jury instructions or intended to file?
Have they
jury
rested?
instructions?
We do, Your Honor. We're working on a couple. I'd like to have a.
I'm open to suggestions.
Before we waste a lot of time.
I'm open to suggestions on how to handle this.
Have
jury.
we rested?
Do you think we're going to get these jury instructions together? What time it is, and get this?
Yeah, we're not getting in that
jury at a
conversation here.
reasonable Time or not?
I do not.
Your Honor, I have filed instructions. I have not received their instructions, but I do have to submit additional instructions. So I don't think that we will get into them.
Well, let me ask this. If we started right now, what time do you think we could have jury instructions together?
2 hours, probably.
2 hours? You think we could have it ready to go to jury? If we worked under the assumption we could have this matter ready to go to jury at 5 o'clock, I'm not saying, I'm just saying if we could work under that assumptions with the parties, the jury's not going home this afternoon anyway. They're either going to be sitting in the jury room or sitting at the hotel or deliberating. Do you think
They're
we could put it
sequestered
to the jury this afternoon or not?
Y'all, I didn't know they were sequestered. Yo, that sucks. They're going to come back with a quick response. Quick.
Prepare to do the presentation for closing arguments.
Super quick.
Finish the jury instructions today, if that's possible.
Yo.
All right, I'm gonna send the jury, you've rested in front of the jury. I'll let the state finally rest in front of the jury. I'll send the jury back and have them back at 8:30 in the morning, being prepared to move forward with closing, reading the jury instructions and closing. Y'all got anything else I need? Anything I'm missing? All right. We ain't leaving till we get jury instructions, whenever that is.
I agree with that, Your Honor.
All right. Show the jury back in.
Does it really matter? Does it really matter?
Okay, it may be, we got one missing. Now we got two missing, but it's gonna be good.
Oh my gosh. So y'all, we got our coffee in from the Hitchman Homestead Shooter Shack Coffee. We are setting up our display. We're going to start selling it. It's going to be awesome. And I'm so excited. So I'm going to go and do a commercial. I got to get a commercial done and get it on the website. I mean, on the Facebook and all that. I am excited. Y'all, if y'all have not tried the Hitchman Homestead coffee, if you are a coffee person, it's fabulous. And if you love tea, oh, who was it that ordered the tea? Who ordered the tea? I'm having a hard time remembering. I hope you enjoyed the tea. I know I sure did. I do. I don't drink it as much on I don't drink it as much on screen as I do off. I probably should drink it more. I know it's bad. I know I'm bad. I'm bad. Sorry. Well, no wonder they wanted to work over the weekend. They're trying to get this stuff done. Hello, it was Brit. That's right. It was Brit. My son's looking around going, where am I going to put all this? Oh, I hope she liked it. I really do, because it's good tea. It's clean. Doesn't have that chemical aftertaste. It's a pure tea, which is important in my humble opinion. I did not know, y'all, there were so many freaking wooden spoons and stuff. No clue. I wanted to get some wooden cooking utensils for camping. There's too many to choose from.
So that quick as Dana gets back, we'll bring them back in, okay?
They're going to bring them back in. Sorry. My back is better. Thank you so much. Still tender, but it is better than what it used to be. That is for sure. I've got to get used to the wheelchair, though. It's going to take an adjustment, especially in the back release, because it's a lower back, which was what I wanted, but I have to get used to the lower back. Talking about the tea, the coffee, we're excited. Hopefully people will start buying. It's Christmas time. People love coffee.
All right, the defense having arrested, the state having wish to call any rebuttal witnesses.
No, Your Honor, this time the state address.
All right, state has arrested. That means you've heard all the testimony that you're going to hear in this case. I've got to sit and watch everybody else work. Now I got to do the start doing some work.
Oh, God, get on the mic, please.
When you hear that law, you don't have to figure out, then you can't come up with it. That's going to take a while. I've got to listen to these guys argue about what they think the law should be and what instructions I should be giving y'all, just like the law is. That's not going to happen in time today for y'all to make this decision. I want to excuse you for the evening. We'll be back at 8:30
I will
in the morning,
excuse you.
and as soon as we get back, we should start hearing closing arguments. I'll read the jury instruction to you. Y'all have a prepared closing argument, and then y'all will finally begin your deliberations. Not yet. Remember the court's instructions. Don't discuss the case even amongst themselves. Don't press for forming opinions until you've heard the law.
I did not know that they were sequestered, y'all. See my reindeer? It's flying.
And we'll see you back at 8:30 in the morning, okay?
9 o'clock our time. Yay, we may be done with this by tomorrow. Go figure. I know I'm squinting because I have the fan on. Maybe I should put my glasses on. Oh, maybe I won't squint so much.
All right.
Are y'all good? Or do y'all want to watch the
I
jury
think,
instructions? Or y'all good for the day?
Given y'all, or Brooke has probably delivered y'all court standard instructions. They're the same ones been used in this district forever. I'll make sure y'all get copies of that. If y'all would, if you haven't filed your instructions, let's go ahead and get them filed now. And And do you wish to have an on the record conversation first, or have it in chambers preliminary discussion of the jury instruction before we?
Why are you asking? You're the judge.
I've never presented to this court before, and I like to have discussions with the court about it before we waste a bunch of time.
Okay. They are going to be doing behind the scenes stuff. I am not really interested in streaming that if y'all are okay. I am gotta go get that that coffee stuff set up, get some tea set up, start getting a little bit of both set up. That will be awesome. I am excited. We're finally going to start getting some toffee and tea sales in here. Yeah. No, I'm good for the day. I need to get some things done I've not been able to get done. But I want to say how much I appreciate every single one of you. Y'all have been phenomenal. I could not be here without you. All my mods, y'all rock. All those who are watching and did not comment or anything, that's wonderful. Lurk all you want. I appreciate your lurking. We will be on tomorrow morning for the rest of this trial. And I am looking forward to this one getting done. Y'all, this has been a struggle. I'll admit, this has been a struggle. Well, Rudolph and I are going to go get some things done. I still have to do some shopping. I'm not done. I need to go take care of some business. I need to have some time to leave and do. So I'm going to be done before 6 o'clock. Yay! All right, guys. Miigwech. Have a great day. See you tomorrow. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.